Watson's Magazine, Georgia, USA, August 1915. The celebrated case of the State of Georgia versus Leo Frank. Author Thomas E. Watson. Read by John de Nugent. As an explanatory note to the listener, this audiobook continues a series of articles from the pages of Watson's Magazine, read aloud for you today in 2015, but composed 100 years ago in 1915 by the heroic and crusading publisher, lawyer, and political leader Thomas Edward Watson. Watson's illustrious career in legal, political, and publishing service to humanity, to the white Gentile race, and especially to the humble, decent, working people of the South and of his native state of Georgia, was crowned by these great articles, found in the January, March, August, September, and October 1915 monthly editions of his eponymous magazine. Their history-making effectiveness is proved by the fact that they led directly to the one and only lynching of a powerful Jew in North American history, that is, to the seizing from prison and hanging of the Jewish pedophile, B'nai B'rith of Atlanta president and child murderer, Leo Max Frank, in August 1915, shortly after the article came out, which you are about to hear. Watson wrote 2 post-mortem articles as well, in September and October of that year, 1915, justifying the execution by the people of Frank, and he was elected as a hero by the people of Georgia in 1920 to the United States Senate, where he served until his death in 1922. Yes, due to the mighty pen of Thomas Edward Watson, plus certainly also the shocking nature of the crime, the beauty and purity of the child victim, the sympathy for white children forced to work 56 hours a week in factories for lecherous northern Jews, and the nationwide Jewish campaign against the people of Georgia involving threats, bribes, and media mudslinging. A people who, by the way, had not been at all anti-Semitic before Leo Frank. The finest men of Georgia, judges, a former governor, the sheriff of Cobb County, businessmen and lawyers, stormed the prison, pistols drawn, where Frank was being held, and avenged with the rope the rape and murder of a 13-year-old working-class factory girl, the beautiful, friendly, kind, virtuous child labor Mary Fagan, who had just ironed her little Sunday dress for church the next day, and was raped and murdered by her own Jewish boss on Confederate Memorial Day. It is important to note in regard to this lynching of a powerful Jew that 3 juries and 5 instances of the court system, county, state, and federal, including twice the United States Supreme Court, had condemned Frank, either indicting him, finding him guilty, or rejecting all his many appeals. But when a crooked governor named John Slayton commuted Frank's death sentence to life in prison, preparatory to getting him yet another trial, and incredibly, Frank was literally a client of the governor's law firm, the outraged and disgusted white men of Georgia had finally had enough, and they acted. The stirring mobilization for justice by the top men of Georgia for this poor little auburn-haired Irish factory girl was in large measure due to this article, which you are about to hear from Watson's Magazine of August 1915. What is especially rewarding also about this issue is how Watson adds new reasons for the guilt of Leo Frank to the previous 2 articles in his magazine, and is not merely rehashing his old talking points. As a trial lawyer for 25 years, Watson was a legal expert himself, and very good at explaining the law to his lay readership, most of whom certainly and fortunately had no reason to be experts on murder investigations or trials. Watson asks, 1. Why, if there was a mob spirit and rampant anti-Semitism, did the Atlanta Dream Team of Rosser and Arnold not change the venue of the trial? 2. He gives more details on Mary's blood found on the 2nd floor and on what a loser Leo Frank was. He spent all afternoon in the factory trying to cover up his tracks as the murderer, but he neglected the most obvious thing, cleaning up the murder scene. With hot soap and water, Frank could have removed the blood of his victim from the wooden factory floor, and much better than by smearing Haskellite on it, that is, potash, which left a huge grayish mess. What was he thinking? Obviously, he was freaking out and panicking by not destroying the evidence. Further, Frank could have easily inspected the lathe that Mary fell against when he hit her in the eye, whereupon she slumped to the floor, passed out. He should have removed the strands of Mary's hair from the lathe, since he was the one who knocked Mary against the lathe by clobbering her. In falling back, she got a 2-inch gash in her scalp, which was cut down to the bone of the skull, a shock which doubtless knocked the girl out. As Watson here points out, the one blow actually led to 2 wounds, front and back, the black eye and the gash on the back of the skull. It is just amazing that Frank did not clean up the crime scene, neither blood nor hair, for all his vaunted Ivy League education and engineering degree, which normally produces a man of a logical and practical mind. Leo was really what in Yiddish, the language of his German-Jewish ancestors, would be called first a nudge, a pain in the neck, because he irritated all the decent girls in the factory with his sexual come-ons and got nowhere with most of them. In fact, 11 testified against him, so he was no charmer. 2, he was full of chutzpah, or chutzpah, nerve, another Yiddish word for you. And 3, he was a nebbish, a loser, because if you're going to murder someone and carry the body elsewhere, don't forget to go back and clean up the traces of blood and hair. Putting the body in the basement could shift suspicion toward the night watchman, but leaving the blood and hair still up on the second floor at the crime scene and not cleaning it away was just plain stupid. Instead, Frank's nutty scheme was to get the black janitor, Jim Conley, to write fake notes posing as Mary Fagan, who in these bogus notes is herself supposedly describing being raped, quote, "he play with me," unquote, by the black night watchman. Did Frank think Mary spoke in Negro dialect? I really cannot think of a worse use of Frank's precious time on Saturday afternoon than forging ludicrous notes by the supposed Mary, describing how the night watchman was raping her. Why would she even be in the factory at night? Her goal was to pick up her pay quickly at noon from her despised boss, and then go to the Confederate Memorial Day Parade, not wait in a dark basement for 4 hours for the black night watchman to come on shift and rape her. And while harebrained Leo Frank was cooking up his Mary Fagan death notes, her family began putting the alarm out about their missing daughter. 3. Watson also shows 2 publicity photos from a Hearst Selig movie glorifying Leo Frank as a heroic martyr of the evil anti-Semites. The very dark, curved-nosed, and even reptilian-looking Semite, Leo Max Frank, is portrayed in this movie by a handsome actor looking like the ultimate square-jawed wasp movie star. As for his rather homely, masculine-looking, and overweight wife, Lucille Selig Frank, she is portrayed as pretty, petite, and utterly devoted, whereas the real Mrs. Frank refused to visit her adulterous husband in jail for over 2 weeks, suggesting she herself thought him anything but innocent. In fact, though this came much later, when Mrs. Frank died in the 1950s, she refused to be buried in New York City next to her supposedly innocent husband, and was buried in Georgia next to her own kin. 4. Watson adduces also the reasoning of the sickening governor of Georgia, the sellout John Slayton, who in his statement justifying his commutation of the death sentence for Frank to life imprisonment, claimed that the massive amounts of blood on the poor girl's panties came from her menstruation, her period. I guess Slayton wanted to sell the public on the idea that Mary was some girl raised by wolves in the forest, and not by a loving, normal, and attentive mother who taught her, as all proper mothers do teach their daughters, how to keep herself clean and hygienic during her period. It is inconceivable that Slayton could believe for even a second that Mary would go to the Confederate Memorial Parade in a light-colored dress with blood stains all over the crotch area. Speaking for myself, having 2 daughters and 2 granddaughters, and as a former Marine and just as a man, I would like to fly back in a time machine to 100 years ago, confront this fiend for his vile defamation of the good character
of both little Mary Fagin and her loving and very proper mother, and just break this liar's jaw. In every way, morally and physically, Mary Fagin was above reproach, and she was humble despite her beauty. All this explains why public revulsion at the crime and at the sex-fiend criminal was so intense. I will add, and please pardon the graphic nature of the following comments, that the loser Frank was unable to succeed even as a rapist by ejaculating, for the autopsy found no traces of sperm. My suspicion is that this fiend used some object, a pencil or hammer, to injure her vagina and her anus, causing the flow of blood all over the poor maiden's panties and dress. We know she unfortunately was alive when she was raped by Frank, because her tissues did swell up from the abrasions. Hopefully, she was at least unconscious. In a way, to me, the only unfair thing is that they only hanged Leo Frank. I have before me the case of an Oklahoma black man who had sexually attacked and murdered a 16-year-old white girl. He was hauled out of jail like Leo Frank, but, unlike this Jew, he was stripped naked, and as he prayed in vain for mercy, he was doused in gasoline, set on fire, and then hoisted up by the noose to strangle. I really think Frank's crime was far worse. 1. The rape was very premeditated and carefully planned out. 2. Frank attempted to send both his own innocent black employees to the gallows in his place. 3. He engaged in a massive campaign of vilification of the people of his own state. 4. He engaged via his minions in countless attempts to bribe witnesses and public officials. And 5. As discussed earlier, he did perverted and sadistic things to the private areas of an unconscious little girl. So I'm sorry he was not slow roasted on a barbecue to relive just some of the horror and pain he inflicted on that little girl in the last moments of her life, not to mention his harm to his wife, his state, to America, and to his own Jewish people to this very day. Had he just accepted his guilt and punishment like a man, he would have done himself and all of us a great service. But when given a final chance by the lynchers to say his last words, Frank still refused to confess, and merely gave them his wedding ring to give to his wife, which was in fact duly mailed to her home out of respect for his last wishes. But Frank never came clean on what he did, right down to the end, and went to judgment an unrepentant, murderous, raping liar, like so many of his people. Point 5. As Watson wrote, quote, "A governor cannot practice law openly," and in June 1913, John M. Slayton was to be inaugurated for a term of 2 years. Why, then, did he in May 1913, that is, a month after the Fagin murder and the arrest of Leo Frank, join a firm with which he could not openly act until after June 1915? And why did Rosser, in May 1913, take on a partner whom he could not openly use during the next 2 years? The answer is obvious. Frank's own relatives and his own lawyers knew he was guilty, expected he would be convicted of murder and sentenced to death, and wanted the governor in their pocket to commute the death sentence so Frank could eventually get a new trial and then get off scot-free. 6. The Georgia Supreme Court was divided only on whether Frank's whoring, sexual obsessions, wild parties, and his fixation on anal sex should have been admitted as testimony. It was, after all, technically a murder trial, not actually a rape trial, because of the detail that no sperm was found. But as Watson points out, this is a mere quibble, and in my opinion, a foolish quibble, involving the question of whether Judge Roan ran the trial 100% perfectly or not. I think the man's obsession with sex, and the perverted kinds of sex he craved, did shed light on his uncontrollable, narcissistic, and perverted nature. A married man who loves anal sex with whores may love other twisted things as well. Frank demanded that his every sexual urge be satisfied, even in his own office, with his janitor as the lookout, and even in the filthy basement of the factory where he held his orgy parties. And as Watson notes, every judge on the Georgia Supreme Court did vote to refuse to rehear the case. Whether they thought Judge Roan had conducted the trial perfectly or not, by admitting the tawdry sex details. They all understood that Frank had been convicted of murder not for being a perverted sex fiend, but by the logic of where he was at the time the murder happened. And that was right there, alone, with Mary Fagan, on the second floor, near the restrooms, near where her blood and hair were found. Frank admitted in his own statement to the jury that he may have gone to use the bathroom at the exact moment she died, next to said bathroom, and remember, there was no one else nearby. It was a Saturday afternoon and a legal holiday. No one else was within 200 feet of the crime scene. Plus, a train of witnesses said that the factory superintendent, Leo Frank, had repeatedly come on to Mary, and her friend testified that Frank had insisted Mary come in personally to pick up her ridiculously tiny pay packet, that he would not give it to the friend for her. 7. The U.S. Supreme Court, on April 19, 1915, notes in an acid tone, in rejecting Frank's appeal, that the Frank lawyers neglected to provide full information to the judges about the case, namely, quote, the rebutting affidavits submitted in behalf of the state of Georgia, and which, for reasons not explained, Frank had not included in his petition, unquote. This was an unpardonable breach of procedure. It disrespected the U.S. Supreme Court, and the failure to provide the arguments used by the state of Georgia against Frank aroused their suspicions that he was, quote, playing a fast one, unquote, to use the vernacular. 8. As Watson further reminds us, quote, remember that one of these two men, Frank and Connolly, successfully withstood a cross-examination of 8 hours, while the other refused to be cross-examined at all, end of quote. Yes, the uneducated black janitor let himself be grilled for 8 hours, and he passed with flying colors. But Leo Frank, the Ivy League graduate, did not allow any questioning. He merely read his long statement to the jury, and, not under oath, not swearing in the Bible that it was, quote, the truth, the whole truth, and nothing but the truth, unquote, then the Jew just sat back down. The effect of this arrogance on any jury is obvious. 10. Watson has actually made this point in previous issues of his magazine, but he restated it very clearly in this issue. Quote, Frank belonged to the Jewish aristocracy, and it was determined by the rich Jews that no aristocrat of their race should die for the death of a working-class Gentile who was, quote, nothing but a factory girl, unquote. 11. Watson also points out that the executive power, under common law, whether it be that of the King of England or that of a governor of an American state, has no right to retry a case or even re-examine a case. No king, president, or governor is a judge. He is there to carry out 1, the laws of the legislature, and 2, after trial by a jury of the people, carry out the sentence. No king, president, or governor is some sort of final appeals court that can overturn a verdict. The only power of the executive branch after a trial is to pardon, that is, to forgive a criminal who has some extenuating circumstances. But that pardoning power still proceeds from the verdict that the man was guilty. No king and no governor can exonerate a person who has been convicted. That would be mixing together the powers of the executive and the judicial branches of our government, and assaulting the 1,000-year-old tradition of trial by jury. When the jury returns its verdict, the people have spoken, and the guilt or innocence of the person on trial has been determined. Given the fact that Leo Max Frank was found guilty by the county of Fulton, the state of Georgia, and the highest federal courts, I suppose Governor Slayton could have claimed an extenuating circumstance such as this. Yes, he did kill her, but only in self-defense. See, Mary was a black belt in kung fu, and a ninja nymphomaniac who tackled the chaste and pure Leo Frank and tried to rape the poor man. He had to strangle her to fend her off, and of course rape her to see if her heart was still beating. Well, Not even John Slayton trotted that extenuating circumstance out. Instead, he, unconstitutionally, as governor, criticized a trial that both the U.S. and Georgia Supreme Courts had upheld, and he claimed that mob pressure had influenced the jury. One can thus understand the boiling rage in Thomas E. Watson, a lawyer, publisher, patriot, and a father of 2 daughters himself, Agnes and Louise, as well as of a son, that made him memorably write the following fiery passage in this article, a paragraph that by itself may have triggered the justified lynching of Leo Frank. Jew money has done for a foul sodomite and murderer a thing that shatters all precedents, nullifies the highest law, sinks juries and courts into contempt, brings upon us a sickening consciousness that our public men and our newspapers are for sale, weakens the defenses of every poor man's home, and adds to the perils that beset every poor man's child. And Watson ends with a reference to the famous Lucretia, a Roman wife who was raped by the evil Etruscan king's son, and then committed suicide dramatically before her male relatives, demanding that her honor be avenged. Watson writes in the grand finale of this article, "Like the Roman wife of old, we feel that something foul, something unutterably loathsome, has crept to bed with us and polluted us during the night, and that while the morning has come, it can never restore our self-respect. We have been violated, and we are ashamed." As my final note before I begin the reading, Mary Fagan weighed about 107 pounds, which did not make her overweight, but she was a strong little girl for just 4 feet 9 inches. 4 feet 11 inches, and having studied up on Leo Frank for over 4 years now. I bet the fatal scene went like this. He came at her very suddenly with a vulgar remark such as maybe his usual "how about it," flickering his lustful eyebrows up and down, and vulgarly flashing some cash at her, or maybe he said something much more blunt and vulgar, and then did some unwanted touching. I suspect she then pushed him away, and when he grabbed for her anyway, she smacked Frank but good in the face. I suspect her Scotch-Irish temper had simply had it. With this guy, after months of his harassment and his leering, twisted remarks, and then, to top it off, making her come in unnecessarily, in person, to collect her microscopic pay, and that on a holiday. I cannot prove, but I suspect that he grabbed at her, and she smacked him but good in the face, and that would have triggered his rage at being spurned, and thus the vehemence of his blow, a punch right to the eye that threw her little head back against a steel machine and gashed her skull, knocking her out. We do know from the trial testimony that the lecherous Frank had gotten the brush off from many a decent girl before, and without, as far as we know, resorting to murder. But Mary was probably by far the most beautiful female he had ever lusted after, and thus he targeted her. He likely had the serious hots for her. She was to be his greatest conquest, and his libido had been on fire all week long that she was out of the factory due to being laid off by the lack of the metal tips for the pencils. I think Mary Fagan looked at him with a hellacious, red-headed scorn and blazing, angry blue eyes, despising this vile and scheming reptile with every fiber of her being. Once he hit her, he realized he would have to kill her, because after his disgusting words and the physical attack, a live Mary Fagan would be at war with this Jew. The whole world would find out about him, and what an arrogant little pervert he was, including his own wife. And this catastrophe Mr. Big Business Jew could not afford. Besides, how dare a Gentile girl turn down a Jew? Does not the Talmud say the Jews were given the world by God, and that the Gentiles were mere animals, created to be their slaves? Well, Mary did not see it that way. God bless this heroic little white girl, who fought and died for her honor, and may Mary Fagan now bless us from where she is now, in our struggles today, to end once and for all the Jewish tyranny over our suffering nation. And may God bless Thomas E. Watson, too, who awakened his people to caring, to outrage, bravery, and heroic action via this article.
And now the article itself. August 1915. The celebrated case of the state of Georgia versus Leo Frank, by Thomas Edward Watson. The laws of Georgia are extraordinarily favorable to a person who is accused of a crime. He is not only protected in all of his rights under the Constitution of the United States, but enjoys privileges far beyond those limits. No indictment against him will stand if it can be shown that a single grand juror was disqualified or failed to take an oath on that particular case. Therefore, our grand juries are bound in each case by a special oath, in addition to the usual general oath, and they examine the witnesses in each case separately, behind closed doors, having the right to call in other witnesses besides those named by the state's attorney. The law authorizes the judge to remove the case to another jurisdiction himself, whenever the circumstances satisfy him that the ends of justice require it. If the judge does not act upon his own initiative, the defendant's counsel can move for a change of venue, and supported by affidavits tending to prove that the feeling in the community is so excited against the accused that it is impossible for him to therein have a fair trial. Our code is also exceedingly lenient in the matter of continuances. The absence of a material witness, the illness of leading counsel or of the defendant, the want of sufficient time to procure important testimony are among the grounds upon which accused persons gain time, and these motions are continually being made for no other purpose than to allow for the passing away of whatever local prejudice may have been aroused by the first rumors and exaggerations incident to most crimes of violence. If the defense is ready for trial and makes no motion to change the venue, each juror of a legally qualified panel is subjected to a rigid examination as to his freedom from bias and prejudice in that particular case, and the defendant can put each juror separately on trial, the judge being the trior, and offer against the juror such evidence as will prove that he is not, in the eyes of the law, a fair juror to try that case. During the trial, the defendant may act wholly or in part as his own lawyer. He may interrogate the witnesses, and he may address the court. If he does not choose to make a statement in his own defense to the jury, he may remain silent, and the law does not permit the state's attorney to comment upon that silence. He may write out a statement in his own defense and read it to the jury, or he may tell his story in the usual way of verbal narrative. He can cover almost any ground he pleases, and he can talk as long as he likes, and if he omits any fact or explanation which his lawyers consider material, they are privileged to direct his attention to his failure to cover that particular point. After the defendant has finished his statement of 10 minutes or 10 hours, and has been aided by the vigilance of his lawyers, he can say to the state's attorney, "I am willing for you to ask me about the case." But if the defendant does not voluntarily make this offer, the state is not allowed to interrogate him at all. Nor is the state's attorney permitted, in his address to the jury, to comment upon the fact that the defendant was unwilling to be cross-examined. In no event can the accused be put under oath, but our law makes it the duty of the judge to instruct the jury that it is their privilege to attach to defendant's statement just such weight as they see fit. They may believe it in part and disbelieve it in part. They may reject it entirely, or they may accept it entirely. They may disregard all the sworn testimony in the case and rest their verdict on the unsworn and uncorroborated statement of the accused. In all the legislation mercifully designed to protect innocence and to give to a man of good character the golden opportunity to stake his word against the oath of unreliable witnesses, there is nothing which surpasses the Code of Georgia. Time and again I have seen a defendant at the bar rise like a lion from his lair and make a manly, ringing, indignant statement to the jury, and shake off from himself the evidence of circumstances or of perjury as easily as the leonine monarch shakes the dewdrops from his mane. Again and again, during my quarter of a century in the courthouse, I have seen my clients and other lawyers' clients confound the prosecution by facing the court and country and saying with the boldness of conscious innocence, "Cross-examine me to your heart's content. I have nothing to hide and nothing to fear." Such a waiver of legal screenage half wins the battle, the very instant the defendant makes it. Let me say at this point, in order that you may enter the case properly informed, that the attorneys of Leo Frank were the most experienced and most competent members of the Atlanta bar, thoroughly familiar with local affairs, local prejudices, local politics, local ins and outs of all kinds, and yet they did not move to continue the case, nor did they ask for a change of venue. Consequently, those Atlanta lawyers were not aware of any, quote, mob spirit, unquote, at that time. Afterwards, it became necessary to manufacture things which had not existed, and the, quote, mob spirit, unquote, which Frank's able attorneys had been ignorant of, was found somewhere in a small file, was released, expanded, blown upon the four winds, until it became greater than the genie of the 1,001 Nights. Those who continue the cry of mob spirit and jungle fury and psychic intoxication convict Frank's lawyers of not knowing their own business. And 1230. For if a tenth of what is asserted was ever capable of proof, then Rosser and Arnold grossly mismanaged Frank's case. Let me say further, by way of preliminaries, that the defendant, Leo Frank, listened during the 8 hours cross-examination of his alleged accomplice, Jim Conley, that he listened day after day and week after week, while his own trusted employees and former friends gave evidence which linked around him the chain of circumstances, that he saw and heard the 11 white girls who swore that his character for lewdness was bad, that he listened to the white girls who swore to his lascivious conduct in their dressing room and to his taking Rebecca Carson into the ladies' private room during work hours and remaining inside, alone, with her for 15 or 20 minutes, and that he sat silent while his Negro trustee, of 2 years' standing, told the jury how he would peep through the keyhole and watch Leo Frank commit sodomy with Daisy Hopkins. So when this educated young man, this graduate of the Ivy League University, Cornell, at last took the stand to make a statement in his own defense, he drew around himself the screenage of our most lenient code of Georgia, and did not dare to say to court and country, "I am willing to answer questions." In all that month of tedious, desperate conflict, Leo Frank was the only person involved who escaped the ordeal of cross-examination, excepting the 11 white girls whom his own lawyers dared not interrogate. The state cannot go further than to inquire whether the defendant's character is good or bad, but the defendant can go into particulars and can inquire of the witness, "What is it that you know against me?" But in this case, Leo Frank did not put the white girls to the trouble of pulling the cover off his double life. He and his lawyers were only too glad to let the ladies go without a word after they had sworn he was bad. It should deeply interest you to learn that 11 unimpeachable and disinterested white witnesses testified to Frank's double life, and that what they knew of him was learned by them in his place of business, where Mary Fagan came to her death, and Frank was so certain the 11 white witnesses would only make it worse for him on cross-examination that his lawyers were afraid to ask those women what it was they knew. Is that the conduct of innocence? Narrator's note. I would like to add at this point that there is a reason why Thomas Edward Watson keeps referring to certain witnesses as white witnesses. The reason why he was emphasizing their race is because the lawyers for Leo Frank and the Jewish-controlled newspapers around the United States had shifted the entire blame on Jim Conley. And despite all their purported liberalness and we love the blacks and whatnot, they were playing the race card now and saying this drunken brute of a Negro and emphasizing that he was black. And they were constantly saying the only thing which is sending the innocent Leo Frank to the gallows is the testimony of a drunken Negro. And, implying you can't trust the testimony of a black man. Well, so since they're now flipping around and saying the word of a black man is worthless, even though they otherwise claim to be liberals, but to get the Jew Leo Frank off, they are flipping, it is necessary for Thomas Watson to emphasize all the white witnesses in that case who were saying that Leo Frank was a pervert, he was a creep, he was a sexual harasser of these girls, and that his character was bad. That is the reason why Watson keeps emphasizing white witnesses. And now back to the article. On Memorial Day, 1913, April 26th, Mary Fagan left her mother's home shortly before noon after having eaten dinner. Actually, this is 100 years old, the American English language of that time. Dinner would mean, in this case, lunch or luncheon. And she was dressed in such cheap finery as a girl of her humble station in life could afford. Narrator's note, a very simple cotton dress. She took the streetcar on her way into the city and left it at a point some 300 yards from the National Pencil Factory where she worked. On account of their running out of the metal pencil tips, she had been laid off that week after Monday, and she was now on her way to the office to get her Monday wages because Frank, the superintendent, had refused to send it to her by her friend Helen Ferguson the day before, when Helen had asked for it, as she had often done previously. When last seen, Mary was within 2 blocks of the factory, to which 2 or 3 more minutes' walk would have carried her, but no one saw her when she entered it. That night her people gave out the alarm, for they at once suspected foul play. Mary was not quite 14 years old, and had never been irregular in her habits, nor ever out at night, and her failure to return home created the most distressing anxieties and forebodings. The police were notified, and a search for the missing girl commenced. At first it was believed that she had overstayed herself with some party of friends enjoying the holiday, and there were vague reports of her having been seen first with one companion and then with another. But none of these rumors proved well-founded, and the dread apprehension of something tragic grew stronger and stronger in the household of the mother, and also among the police. During all of that evening, the efforts to locate the missing girl continued, but nobody appears to have thought of calling up the Leo Frank house and asking him had he seen her. True, he would not have been found at home. He was spending that particular afternoon alone in the factory. But neither Mary's folks nor the police suspected it. Let us now turn our attention to Frank and follow his movements that Memorial Day morning. In parting from the night watchman, Newt Lee, who of course went off duty early, Frank asked him to return that afternoon at 4 o'clock. Frank explained that he wanted to get off earlier than usual. During the morning, Saturday the 26th, several employees and relatives of employees came to get wages due and got them from Frank. 2 men, Denham and White, were at work on the 4th floor, tearing down an old partition and putting up a new one. Necessarily, they made a deal of noise at this kind of work, and they were doing it some 200 feet back from the elevator shaft and stair landing. Consequently, they were the less apt to hear a scream 2 floors below, or to hear the sound of a fall, or to hear the elevator if it ran. The wife of one of these workmen, Mrs. Arthur White, came to the factory to see him at 11:30 in the morning, and unexpectedly returned at 12:30. She was not an employee, and she did not know Jim Conley. But Mrs. White and two white men, Graham and Tillander, swore that they saw the Negro sitting not far from the foot of the stairs on the first floor where Conley worked, and where he generally sat when idle. Leo Frank's office and place of work was on the floor above, and his desk was in the inner room, while the safe was in the outer. The time clock was nearby, and it was Frank who put in and took out the slips of paper on which the punches were registered. Narrator's note: I've actually done 40 years ago a little bit of night watchman work myself, and the way the system worked for many generations was you would have a device or a piece of paper, and there were different little clocks all around the factory, and so you had to go in a specific order from one clock to the next, up the hall and down the hall and up the stairs and down the stairs, and that proved that you actually went to that part of the factory because there was a time clock, and then you went to the next station and stuck the piece of paper in, and it put a time stamp on there, and that proved that you were there. And then you went to the next station, and the time was slightly later, and that was stamped, and so forth. And that proved that you went around that factory and the exact moments when you were at each station. This forced the night watchman to keep moving all night and to actually cover every important place in the factory. Back to the article. Leo Frank stated again and again that he left his office at about 11 o'clock that morning. He went to his Uncle Montag's place of business, and that after his return to his office, he never left it at all until he went home to dinner, that is, luncheon, at about 1 o'clock p.m. He did go to Montag's, and a white lady of the most unquestionable character made affidavit. Narrator's note: an affidavit is a legally sworn statement. You raise your hand and you swear that you're telling the truth to the police or to a notary public, and then they stamp it with their seal and say, this is a sworn legal statement, a testimony. It's not done in a court, but it's submitted later on, this piece of paper, to the court and to the lawyers and to the judge and to the prosecuting attorney. That's what an affidavit is, a sworn statement, which has, legal validity. I swear that I saw or did this. Okay, back again. He did go to Montag's, and a white lady of the most unquestionable character made affidavit to the fact that she saw him and Jim Conley in close conversation at about 11 o'clock, near Montag's place. This bit of testimony is of superlative importance, and the defendant was never able to shake it in the least. It shows that the Jew was talking in a secretive, confidential manner with the Negro on the sidewalk where he thought he was unobserved, and this Negro had been his trustee for 2 years. This is the same Negro upon whom such a torrent of vituperation was afterwards poured when it became necessary to find a scapegoat for Leo Frank. The story, invented long afterwards, that Conley was drunk and was, quote, hiding behind some boxes in the gloom, unquote, is exploded by two white ladies, Madames White and Waits, and by two white men, Messrs. Graham and Tillander. Taking those 4 witnesses, who have no interest whatever in the case and whose characters are entirely above attack, is it not clear to your mind that both Frank and Conley were on the scene of the crime that Saturday morning, and that each man knew the other was there? Besides, if the court stenographer did not misunderstand the detective Harry Scott, Frank told him on the Monday following the crime that Conley was in the factory that Saturday morning. As the whole argument pivots upon this vital fact, let me quote Detective Harry Scott's exact language from page 80 of the record. I knew on Monday that Mrs. White claimed she saw a darky at the factory. I gave that information to the police department. Mr. Frank gave me the information the first time I talked with him, Monday afternoon. Bear in mind that Scott was a Pinkerton detective whom the pencil factory had employed to ferret out the crime, and that Scott was on the job as a friend to Frank. According to medical testimony, Mary Fagan's death occurred in less than 45 minutes after she ate her dinner. The experts claim that the condition of the stomach proved this. But waiving all questionable evidence, we come directly to what Leo Frank said with careful consideration, knowing that his words were being written down. After the girl's body had been found inside his place of business, and the rigidity of the remains showed that she must have been killed many hours before she was discovered, necessity compelled Frank to admit that she had come into the building that Saturday afternoon. There was no way out of it. The corpse was there. Consequently, the living girl had come. But when? The state followed her from her mother's and onward in the streetcars to the corner of Marietta and Forsyth Streets, and then traced her within 2 blocks of the factory, going in that direction, and in less than 4 minutes' pert walk of its door. Watches and clocks varied as they always do, but the time was right around the noon hour. With the stiff, cold body in his place of business that night, and the girl walking toward the door somewhere near midday, Frank was necessarily compelled to fix a time, at least approximately, for her arrival. And he did so. He told Chief Lanford that the girl came to him for her money, quote, at from 12:05 to 12:10, maybe 12:07, unquote. Leo Frank's stenographer swore she punched the time clock and went away at 12:02, and Frank said that the girl who was killed came next. What he did not know at that time was that another girl had come at that identical time, 12:05, and had remained until 12:10, and had searched both offices for Leo Frank without seeing him or hearing him, and without seeing or hearing anything of Mary Fagan. This girl, whose visit to his vacant office was unknown to Frank, proved the most invincible link in the chain of circumstantial evidence against him. When he afterwards learned the time of her visit, he changed the time of Mary's, but he only sunk deeper into the mire, as will be shown you later. The sum of $1.20 was due Mary, and she not only wanted that pitiful sum, but wished to know whether there would be work for her the following week. Therefore she came and got her pay envelope, and asked her employer, "Has the new metal come?" That was the same as asking, "Will there be work for me next week?" Frank told his detective that he answered the girl by saying, "I don't know." The room in which Mary worked, putting the metal tips on the pencils, was on the same floor as Frank's office. It was some 200 feet away, and a door cut it off from the intervening space. The toilet for men and women was back there, beyond where Mary worked, and the men's part of the closet was separated from that of the women by a thin partition. In going to his toilet, Leo Frank had to pass close by Mary Fagan, where she sat at her machine, and he had been doing this daily for many months. There were only 4 girls who worked in the metal room, and Mary was one of the 4. Remember this, for after the dead body was found, Frank claimed that he did not know whether a girl named Mary Fagan worked for him or not. He said he would have to consult his books. Now let us return to Frank's office, which he claims not to have left at all after his return from Montague's. He told his detective, Harry Scott, in the hearing of policeman John Black, that he was in his office continuously, from the time Hattie Hall, his stenographer, left at 12:02, on until Mrs. White saw him in the outer office at 12:30. Mark you, Frank and Conley are both visible at 12:30, one upstairs and the other down. Only about 30 feet of space separates them. For the present, we will not concern ourselves with the question as to where they were after 12:30, but will ask, where were they between 12:02 and 12:30? Within that brief period of less than half an hour lies one of the blackest crimes on record. Within that brief and guilty period, Mary Fagan enters into the possession of Leo Frank in his private office, according to his own statement. He does not claim that the girl had ever spoken to the Negro, or had anything to do with him, or was in his power that fatal day. He admits that the girl safely passed the Negro, as Hattie Hall had done, the stenographer, as Mattie Smith had done, and as Mrs. White had done, that same day and near the same time. Narrator's note: the reason why Watson is emphasizing this is if the motive of the Negro was to rape a white female or rob her, there were other white females that he could have attacked. But he didn't. In fact, he didn't attack any white females at all. Back to the article. Frank admits that the doomed girl arrived unmolested in his private office, where the two were alone, with no persons nearer to them than the Negro servant down the stairs, and the two hammering and banging carpenters 2 floors above and 200 feet back. He admitted to Chief of Police Lanford, and swore to the coroner's jury, that Mary Fagan went into his office, power and possession, at a time that he variously fixed at from 12:05 to 12:15. Then where was Mary, that Montine Stover could not see her, when Montine was in Leo Frank's office from 12:05 to 12:10? And where was Frank? The state contends that when Mary inquired, "Has the medal come?" Frank answered, "I don't know," and that he took her back to the medal room on the pretense of looking to see whether the medal had come. As they passed into the room, Frank closed the door behind them, thus giving them freedom from interruption, for no one was at work on that floor on this legal holiday. In his statement to the jury, Frank said that if he was not in his office at the time Montine Stover swore he wasn't, he might have unconsciously gone to the toilet. The adoption of the theory not only gives him an unconscious spell of 5 minutes. Narrator's note: let's say the man went to urinate. 5 minutes is a lot of time to just unzip your trousers, urinate, zip back up, and go back to work. So Watson is making an important point here. Just to go pee you don't need 5 minutes for that. There is the 5 minutes, though, that Leo Frank is missing, because Montine Stover was waiting for him for 5 minutes. So he was gone for 5 minutes, unconsciously, to go urinate? Watson is raising that question. Return to the article. The adoption of the theory not only gives him an unconscious spell of 5 minutes, but places him in the medal room where Mary Fagan's blood and hair were found. It not only places him at the place where Mary was assaulted and then killed, but places him there at about the time that it was done. In his desperate effort to escape the logical consequences of Montine's evidence, he runs into a position equally desperate. To place himself where Mary was attacked, at the time she was attacked, is about equivalent to a confession that he was either the principal or the accessory in that attack. Now, to arrive at a correct idea of the manner in which Mary was assaulted, we must have recourse to the testimony of Drs. Harris and Hurt. Both testimonies taken together, they show that the girl was struck a violent blow in front, which did not cut the skin, but which gave her a blue-black eye, just such a blow as a clenched fist usually gives. In the back of her head was a cut to the bone, 2.5 inches long, quote, ranging from down upward. Narrator's note: the significance of that final statement, ranging from down upward, would be that when Leo Frank punched her, she fell back, and the back of her head hit a sharp point of this steel machine. And then as she collapsed unconscious, her skull scraped going downward. And so the scar went up because she was going down. Back to the article. These 2 blows had been inflicted before death, and at practically the same time. The blow on the back of the head had rendered the girl unconscious. There was blood caked in her thick, long hair. There was blood on her drawers, and there was blood on her private parts. There was evidence of violence and some sort of penetration in the vagina, and this penetration appeared to have been made just before her death. The uterus was that of a virgin, and there was no evidence of pregnancy. Her drawers were not only bloody, but torn, all the way up, and a strip of her undergarment had been torn off. This strip had a soft knot tied in it, as if it had been made into a sort of pad to catch the blood, and this pad had soaked up the blood and was full of it. Therefore, it had been put under the cut in the head. In the removal of the body, the strip had slipped, and it was found lying loosely around the girl's neck, where it served no purpose of the murderer, for the cord did all that was necessary. Narrator's note, necessary for strangling her. Back to the article. For the present, we will continue ourselves with these physical details and endeavor to ascertain what they mean. Unless we are ready to believe that this pretty little white girl, dressed for the Memorial Day, was more filthy in her personal habits than the commonest wench, you will reject with disgust the contention of Governor Slayton that the blood stains came from her monthly sickness. No bandage was on her person, and her underclothing was violently torn, and she was bloody, and there were signs of violence inside the vagina. Do you doubt that some sort of sexual attack was made upon her? Be that as it may, the wound which ripped her scalp to the bone bled somewhere, and the question is, where? To cut the inquiry as short as possible, I will say that the evidence in the record fails to show any blood anywhere except on the first floor, at the ladies' dressing room, not far from the metal room door. The immense importance of the blood marks begins to be obvious when the record discloses the fact that the metal room and first floor had been swept up on Friday evening, preparatory to the legal holiday which would close it until the following week. Now, the men who cleaned up the place swore positively that there were no unusual marks on the floor Friday. Mel Stanford swept the floor, every foot of it, and was emphatic in his testimony. Equally emphatic was R.P. Barrett. Both these men were satisfied employees of Leo Frank, and when these two white men, early Monday morning, made the outcry about the blood on the floor, neither one of them had the slightest idea that their discovery would hurt Leo Frank. They found the blood, and they immediately made the outcry, but they did not know whom it would implicate in the crime. Please remember this. At that time, Leo Frank had not been suspected, much less accused, and at that time he was endeavoring to fasten suspicion and evidence of guilt upon Newt Lee, the night watch. These telltale marks on the floor caused excitement among the officers and employees of the factory, and everyone could see that an effort had been made to hide the blood by smearing a white substance over it, Hascoline. Narrator's note, potash. Of course, the attempt to conceal the spots had made them the more conspicuous. There was absolutely no conflict in the testimony as to some sort of spots on the floor and some sort of white stuff smeared over them. To say that the accusing spots of blood were on the floor Friday is to impute willful perjury to two of Frank's friendly and intelligent workmen, a perjury without motive and against their own interest. Narrator's note, what Watson means by this, against their own interest, is if you're a janitor, you're supposed to sweep up the floor, and if you noticed a pool of blood, you should definitely notify the authorities and your boss, and, don't touch the pool of blood. So, clearly, they would have gotten in serious trouble for just sweeping up all these spots of blood.
that was something that had to be reported and dealt with by the police. So they had no interest or motive to lie. They had just done their usual good job. They'd swept the floor clean, and there were no blood spots on the floor on Friday. Back to the article. To say that the accusing spots were not on the floor Friday imputes perjury to no one, for no one swore that the spots were there Friday. Following the rules of law, we are forced to accept the positive evidence that the spots were not on the floor Friday, but were there Monday morning. Then we come face to face with the question, how came the spots on the floor? Say that they were made by paint. Who spilled the paint on that floor after Friday and before Monday, when the factory was closed? Produce the man, the woman, the boy, or the girl. The defense could never do it, and cannot now do it. Say that the spots on the floor were made by blood. Who spilled the blood on that floor after Friday and before Monday? Produce the person who did it. Narrator's note. What Watson is saying is, who was in the factory after Friday and before Monday? Well, there were the girls and the people that came to pick up their pay, and there was Jim Connolly and Leo Frank. One of the girls was Mary Fagan. That's who was in there. Returning to the article, the defense was unable, and is now unable, to produce such a person. Narrator's note, such an alternative person who snuck in and murdered Mary. Back to the article. What then is the conclusion of inexorable logic? Nobody did it excepting the one man who does not dare to acknowledge that he did it. That he may have had an accomplice in it does not alter the state of the case. Reasoning by the process of exclusion, we will say quite naturally that if any person innocent of crime had spilled that blood or paint, narrator's note, in other words, some sort of accident, or they cut their finger or something, or, sloshed a bucket of paint, some workman, back to the article, and had hurriedly tried to cover it with white powder, the innocent person would have come forward when the hue and cry went forth and would have said, I'm the person who made those marks on the floor after Friday and before Monday, and I'll tell you how I came to do it. More especially would an innocent person have done that had he seen another innocent person endangered by the failure to account for those damning spots. But when no person comes forward to innocently explain, what is the inference? It is that those spots show somebody's guilt, and the somebody who is responsible for the spots is afraid to say, I made them. Where does that process of reasoning take us? It takes us to Leo Frank, is the only person in the building who dares not come forward and tell how he came to make them and why he tried to hide them. Subheading: It was Mary Fagan's hair. Let us go a step farther and see what was found in the metal room early Monday morning. Frank's machinist, R.P. Barrett, had been at work in the metal room until quitting time Friday evening, and he left a piece of work in his machine. Immediately upon his return Monday morning, he noticed on the handle of his bench lathe some strands of hair swinging down. He at once called attention to it, and the strands of hair were seen and examined by numerous employees of the factory. The hair was almost immediately recognized as Mary Fagan's, for the only other girl there who had hair like Mary's was Magnolia Kennedy, and Miss Magnolia had not been in the factory at all after Barrett quit work Friday. Narrator's note, of course, the hair color was just sort of a dark auburn blondish color. Her hair has been described as red, blonde, auburn. It was sort of a light glowing, a very pretty color with reddish tones. And the only two girls in that part of the factory were Magnolia Kennedy and Mary Fagan. And Magnolia Kennedy was alive,
And Mary Fagan was dead, so it was very obvious who it was. Back to the article. One of the girls went running to the others, exclaiming, "They have found Mary Fagan's hair on Barrett's machine." All this was on Monday morning, when the general agitation had taken no definite direction, and when the men and girls in the factory were expressing themselves spontaneously and truthfully, without a thought of saying a word that would implicate the superintendent, Leo Frank. Please bear this in mind. There was no frame-up against anybody in the outcry about the blood in the hair, for at that time nobody had any idea of who was guilty. As the hair was not on the handle of Barrett's machine when he took his hands off it Friday evening, and as the hair was on the machine Monday, and as the hair showed itself to be a woman's, and as the girls who knew Mary said it was hers, we must believe that it was hers, unless some girl or woman came forward and said, "The hair is mine, and I will tell you how it came to be on the handle of Barrett's machine after Friday." There were 100 girls and women at work in the place, and only one of them had hair like Mary's, and this one girl, Magnolia Kennedy, said on oath that the hair was not hers, but seemed to be Mary's. What follows? Unless some outside woman's hair somehow got on Barrett's machine after Friday, we must conclude that the hair was Mary's. It is impossible to suppose an outside woman, for one had come to meet Frank or anyone else after Friday. Either Frank or the woman or both would have given that explanation and ended this part of the case. Isn't that perfectly clear to your mind? Let me state it again. If Frank had an assignation with some outside woman and took her to the metal room, where her hair might have dropped on the handle of the machine, is it conceivable that he would fail to thus account for the hair? If any other man had such an appointment with some outside woman whose hair might have got on the machine, would not that man have come forward to save Frank? Why did no such man and no such outside woman pretend to have been the cause of the hair on the machine? Because no such man and no such woman existed. Then we reason ourselves right back into the factory, and we say that the long strands of woman's hair of that peculiar golden brown color came from the head of one of the 100 girls who worked there, and that as not one of these girls can be induced to even pretend that the hair was hers, we under the logical compulsion of saying it was Mary's. Those who would have claimed it, had it been theirs, will not. Therefore the hair didn't belong to any of them. But it had belonged to somebody, and as that somebody cannot be found by the defendant, or by the defendant's lawyers, or by the defendant's detectives, or by the defendant's partisans, we are driven to the conclusion that this undiscoverable somebody was Mary Fagan. Did the defense attach importance to this finding of the woman's hair on the handle of the machine? Did the able lawyers of Leo Max Frank endeavor to account for the accusing strands? They did. They struggled to get away from the hair as hard as they struggled to escape from the blood. What explanation did they offer? They proved that the girls sometimes combed and did up their hair not far from Barrett's machine, and they argued that some woman doing this might have flung her combed-out hair in such a manner that it fell on the crank handle. Very well. Then produce the woman with that kind of hair. Narrator's note, in other words, that golden brown color. Back to the article. The defense is unable to do so. But the state of Georgia goes farther and says to the defendant, produce any girl or woman. Narrator's note, including a loose woman, a prostitute, went in there to have sex with Leo Frank or some other man. In other words, forget the factory girls, any woman, produce any woman. Back to the article. Produce any girl or woman who was in that room after Barrett left his machine Friday. Again, the defense is unable to do it. What follows? Of logical necessity, it follows that as some woman or girl was in that room after Barrett stopped his machine on Friday, and as no living girl or woman can be produced, the girl who was there is not alive. Even the sapient Burns realized to the full the enormous weight of those 6 or 8 strands of women's hair, swaying upon the handle of Barrett's machine. For Burns's man, Lehon, gave out a statement which was thus reported. Narrator's note: now comes a sort of copy and paste of a report in the Washington, D.C. Herald newspaper, as follows. Burns detective declares hair was placed by reporter to get scoop in Frank case. Special to the Washington Herald. San Francisco, March 20. Evidence which it is claimed will clear Leo M. Frank of the charge of murdering little Mary Fagan in Atlanta on April 26, 1913, is in possession of Dan Lehon, a New Orleans detective now in San Francisco. Quote, one of the most startling bits in the chain of evidence which the state wove about Frank was a strand of hair found on the 2nd floor of the factory, unquote, said Lehon today. Quote, I am prepared to prove that the lock of hair was placed on the handle of a lathe by a newspaper reporter for the sake of a sensational scoop, unquote. In March 1915, narrator's note, 9-10 months after the trial, back to the article, Burns and Lehon were, quote, prepared to prove that the lock of hair was placed on the handle of a lathe by a newspaper reporter, unquote. Prepared to prove it, you see. The Burns Detective Agency had abandoned in despair the efforts to find a girl who would say that she went to that metal room after Friday evening, and that the hair might be hers. To find such a girl is doubly difficult, for the reason that Mary's hair and the hair on the machine matched, and that no other girl in the factory had that kind of hair. And it was not only necessary to discover an outside girl with hair like Mary's, but a girl who could swear to an arrant falsehood without being caught in it. Consequently, the noble detective agency abandoned that line, discouraged by the exposure of the bungling briberies of Epps, Duffy, Ragsdale, and Barber. They leave the girls and discover a newspaper reporter. Well, where is he? Who is he? Why hasn't he been produced? The prison commission would have been glad to hear the gentleman. The governor would have been overjoyed to welcome such an ally. The crime was not known to any reporter until Sunday morning. The hair was found Monday morning at 6:30 a.m. So how did the reporter get into the room Sunday without being seen? How did the reporter get the hair? Where did he get it? Did he pull it out of Mary's head in the basement? Or did he go into the morgue after it? Tell us who is the reporter that remained silent during all that prolonged trial of Leo Frank, during all the months of effort to find new testimony, during the year or more that the case has traveled from judge to judge, from court to court, from courts to prison commission, and from prison commission to the governor. Hard-hearted newspaper reporter, who must necessarily have been an Atlanta man, working for one of the Atlanta papers, which have been so partial to and in favor of Leo Frank. Apparently, Burns and Lehon give the public no credit for common sense. These brazen rascals have given out statement after statement, audacious falsehoods, told with confidence and repeated with brazen insistence, because the state of Georgia had no press agency to defend her, and her governor was a partner of the law firm defending Leo Frank. The governor himself was mightily worried about the hair, and when he signed the 15,000-word mass of incoherences which sought to justify his commutation of the sentence, he gave the public to understand that Dr. H.F. Harris had virtually destroyed the value of that part of the state's case. What is the truth of the matter, as shown by the official record? The grave of Mary Fagan was opened, and some of the hair taken from the head 10 days after her death. At the morgue, the undertaker, Giesling, had cleansed the girl's head and hair by washing it out thoroughly with tar soap. Now the doctor was asked to make a microscopic examination of the two tresses of hair, the one found on the handle of the machine, the other taken from the exhumed body. This is what Dr. Harris said. Affiant, that is the person making the affidavit, narrator's note. Affiant further says that the two specimens of hair were so much alike that it was impossible for him to form any definite and absolute opinion as to whether they were from the head of the same person or not, unquote. Were there ever two drops of water, grains of sand, leaves of trees, scales of fish, or strands of hairs exactly alike? Are any two hairs of your head precise duplicates? Is there not a slight variation of texture and size in every two hairs of every person's head? When Dr. Harris's microscope failed to reveal any decided difference in color, size, and texture between the tress that came from the grave and the one that came from Barrett's machine, you may feel as certain as you need feel about anything that the two tresses were once a portion of the same head of hair. That which we do not see, and do not learn from others who do see, we must learn from proved facts, which convince us to a moral certainty. And when the microscope failed to show any difference that a conscientious examiner could swear to, the jury was bound to believe that the hair was the same, unless the defendant could offer some evidence going to show that some other person dropped the hair on the machine. Until the defendant made some effort to identify some other person whose hair got on the machine in some way after Friday, it would not have helped the defense even if Dr. Harris had sworn that the hair on the machine was not the same as that taken from Mary Fagan's grave, for the simple reason that the state and the jury would immediately have said, as you claim that it is different hair, there must be another girl whom you had in your employ and whom you can produce. Produce her. So it must be apparent to you that if Dr. Harris had testified as Governor Slayton insinuated, the defendant would not have been relieved unless he could produce the other girl. And if he could have produced the other girl, he did not need the evidence of Dr. Harris. Whichever way you take it, you find yourself going round to the same conclusion. The hair was Mary's, because they could not prove it to be anybody else's, and it had to be somebody's. Produce the girl who went back there and combed her hair. It can't be done. Produce the woman who went back there and did up her hair. It can't be done. Produce the girl or the woman who will swear that the hair might have been hers. It can't be done. They could monkey with the cook and squelch her. They could monkey with the keeper of the lewd house and run her out of Atlanta. They could buy poor old Ragsdale and E.L. Barber. But they were utterly unable to prevail upon any woman to testify that the hair on Barrett's machine might have been hers. Narrator's note, the cook and the keeper of the lewd house, the whorehouse, Ragsdale, Barber, these were all people who there was evidence of bribery in changing their testimony. So the dream team and detectives and the people with cash were getting some people to change their story, but they could never get any woman to step forward with exactly the same hair color as Mary Fagan and say, yeah, Friday night, at 10 p.m., I had sex on a top of a lathe with Leo Frank or in the metal room. Or, I was combing my hair. They just know, for all their willingness and ability to bribe people, they just couldn't get the right woman to step forward and make that claim with all the money that they had, because they didn't have a woman with the same hair color who could show that she had been there at that time. Okay, back to the story. For heaven's sakes, use your common sense. What is the only solution as to the hair when nobody will claim it? The only possible solution is that the girl who could have claimed it is dead. Dead in her tender youth, in the flower of her maidenhood, in her glory of virginal purity. Dead as your little girl someday, if other Leo Franks escape just punishment through the machinations of big money. tell us this. Oh, tell us this. If that hair on Barrett's machine came from the tresses of some girl who was still alive during the trial, why in God's name shouldn't she have come forward and claimed it? There was nothing to disgrace her. She could have said she went to the toilet. She could have said she stood there by the machine doing up her hair. She could have said that she idly let a few strands fall and they might have caught on the handle of the machine. There was no disgrace to fear. Why didn't the girl come forward? There is but one answer. The girl was dead. If in Mary's uplifted, horrified, frantically opposing little hands there had been found some hair from the head of the simian Jew who was assaulting and killing her, the evidence wouldn't be a bit stronger. Governor John M. Slayton had before him the undisputed testimony of the only possible girl, excepting Mary, whose hair it could have been, and this girl swore it was not hers, but seemed to be Mary's. When the only other possible girl swears herself out of it, what does inexorable logic say? Exclude every other person, and you have Mary Fagan. It was Mary who was there Saturday, and she asked Frank a question which suggested a visit to the metal room. Now, Governor Slayton admits that if it was her hair, it furnished the highest and best evidence of Frank's guilt. Does it? Then Frank's guilt is demonstrated. Again, I repeat, we lose Frank and Mary Fagan from sight at 12:05, and we locate Frank alone again at 12:30, standing in his outer office, at the open safe, and starting nervously when spoken to by Mrs. White. But we do not find Mary any more until 3 a.m. Sunday of that night. That is when the night watch, Newt Lee, in making his rounds, has a call of nature while down in the basement, goes to the toilet there, and in the light of his lantern happens to fall upon the white legs of the dead girl, her dress having been partially thrown back, and she was dragged by the heels over the dirt floor. Narrator's note, Watson is emphasizing the dress having been thrown back or pulled back because women back then 100 years ago wore long dresses, so you wouldn't normally see anything of a woman's legs unless the dress had been pulled back by something such as the wind or being dragged in the opposite direction. Okay, back to the story. Newt Lee rushed up the ladder and through the trap door, got to police headquarters over the phone, and called the officers to come at once. He told them he had found a dead white woman in the basement. They rushed to the place, went to the basement, and examined the body. It was lying on the side face, almost on the face, and the face itself was dark with congested blood, and with the dirt over which she had been dragged. Her tongue was out of her mouth, and around her neck was a thick twine cord, tied so tight that it had sunk into the flesh. Her arms were in a fixed position, folded across the breast. She was rigid all over. Near the body lay her hat, shoes, and handkerchief. There also were 2 notes, which purported to have been written by the girl to her mother, describing how the tall, slim night watch had seized her as she went to the closet and had thrown her down the scuttle hole into the basement. Thus the notes directed suspicion to Newt Lee, who was the narrator's note, who was the night watchman. So this is implying that Newt Lee discovers a body, and he wouldn't look at the notes, which point to him. He just calls the cops. I mean, I would. It's incredibly bogus. We may dismiss at once the idea that Newt Lee could have been guilty, but we must not forget that the notes accused him, positively and circumstantially. If we afterward learn from the record that Frank caused Lee's arrest for the crime and fabricated a time slip for Saturday night, which gave Lee a period of the night unaccounted for on the clock, a sufficient period for him to have gone home and changed his supposedly bloody shirt, and if we further find that Frank hinted and insinuated against Lee until they searched his premises and found a bloody shirt in Lee's clothes barrel, narrator's note, evidence which was proven to be fictitious, that the shirt had never been worn by any human since it was white. It was a fresh shirt. It didn't have any sweat or body odor or nothing on it. And so nobody wore it who had a fight with a little girl and threw her to the ground and raped her, because there's absolutely no body odor on that shirt, which had the blood smeared on it. So it was not worn by a human being since it was last laundered. So that evidence was dismissed. The shirt had blood on it, but it had no sweat and no body odor on it. It was just a fresh shirt that somebody had grabbed and put blood on. Okay, back to the story. If we shall hereafter learn all this from the record, we will be getting close to the man whose active brain dictated those notes. When the officers had completed their hasty examination of the body, they went to the telephone and rang up Leo Frank's house. Newt Lee had already tried for several minutes to get a response from somebody at Frank's house, but had failed. The officers tried, long and earnestly, and they also failed. No one would answer. Subheading: What was Frank's true character? Before we go further, let us see what the official record proves as to the moral character of Leo Frank, of whom the veracious Burns recently said, "And it made them angry when I offered a $5,000 reward for the slightest evidence showing immorality in all of Frank's life. That offer still stands, and has never been sought, and still the stories continue in Georgia that he is a pervert. I have never known a cleaner, more honest, more God-fearing man than Leo Frank. Only his abiding faith in his God has, according to my belief, kept him up through the ordeal he has experienced, and that faith will be rewarded, for he will be proven innocent." Burns's money, the offered $5,000, is somewhat more unattainable than the bag of gold that you can get if you will hasten to the end of the rainbow. If anyone was ever silly enough to become angry when Burns offered $5,000 reward, I never heard of it. Trying to get blood out of a turnip would be a sensible experiment compared to an effort to get that money out of Mr. Burns. What says the record, leaving Jim Conley out of it, concerning Frank, than whom the garrulous Burns has never known a cleaner, more honest, more God-fearing man? The author of the Governor Slayton document, narrator's note, has a little dig in there, like who really wrote the document that the governor signed. Okay, back to the story. The author of the Governor Slayton document says that 100 witnesses swore to Frank's good character, and less than a dozen testified he was lewd. The world is therefore expected to believe that the overwhelming weight of the evidence was in favor of the chastity of the accused. Out of the hundreds of people who are acquainted with young men about town, how many really know their secret sins? How many could swear to anything disgraceful? When 100 Jews go up on the stand and give Frank good character, they no doubt are perfectly honest about it. But when 10 white Gentile girls swear they had worked at the pencil factory under Leo Frank for years, and that Leo Frank's character for lasciviousness was bad, the jury must not disregard this positive testimony and rely upon the 100 negative witnesses. Narrator's note, what Watson is saying here with positive and negative is, they're saying they actually saw something. They saw him coming on to girls. They saw him disappearing into the ladies' dressing room for 20 minutes with one of these women. They're saying, I saw this and I heard that. Okay, that's positive testimony. The 100 negative witnesses, people who say, I never heard that he did anything wrong. I never saw him do this. I never saw him do that. So that's negative testimony. I did not see or hear anything bad. But these 10 girls are saying, I positively saw something, I heard something, I witnessed something. So what Watson is saying here is 10 people have positive testimony to something they saw and heard. And 100 people say, I never saw Leo Frank rape or murder anybody or sexually harass anybody. I never saw it. Okay, so he's saying negative testimony is not nearly as valuable as positive. Okay, back to the story. And when the cowering defendant dares not put a single question to these positive witnesses, their evidence against his character, based on personal knowledge, must be accepted. Miss Myrtis Cato and Miss Maggie Griffin testified to Frank's habit of taking Rebecca Carson into the ladies' dressing room on the 4th floor during work hours, and the attorneys of Leo Frank did not dare to ask those white girls a single question. C.B. Dalton admitted under oath that he and Frank had frequently had a woman of the town in the factory, and that he had even gone to the basement with her. The woman from the outside, with whom Frank was alleged to have indulged in unnatural vice, was Daisy Hopkins, and the defense had to put her up. Narrator's note, it was 100 years ago, more or less the time of Queen Victoria, and people were not very explicit whether this was oral sex or anal sex. It just wasn't said. It was just simply called unnatural vice, because it was not, penis, vagina. It was something considered very kinky. Unnatural. And that's the phrase that was used. I'll repeat that sentence now. The woman from the outside with whom Frank was alleged to have indulged in unnatural vice was Daisy Hopkins, and the defense had to put her up. That is, on the stand. Daisy denied it, of course, and on cross-examination, she gave the following remarkable testimony. I have never been in jail. Mr. W.M. Smith got me out of jail. I don't know what they charged me with. They accused me of fornication. However, when Jim Conley peeped through the keyhole and saw the sight which he swore he saw, you might read page 55 of the record, not for evidence of the guilt of Frank, but to obtain an idea of a pervert. If you will read the Old Testament account of the destruction of Sodom and Gomorrah, you will have a clear vision of the darker slime of this case. I do not care to quote the evidence, but merely cite you to the page. You can find it also on page 285, 141st Georgia Reports. So much has been said about Frank's chaste character, a pet of the rabbi, a favorite of Cornell University, and a model husband, that I will give you a little glimpse into Nellie Wood's evidence. Question: do you know Mr. Frank? Answer: I worked for him 2 days. Did you observe his conduct toward the girls? His conduct didn't suit me very much. You say he put his hands on you. Is that all he ever did? Well, he asked me one evening. I went into his office and got too familiar and too close. Did he put his hands on you? Well, I did not let him complete what he started. I resisted him. Did he put his hands on your breast? No, but he tried to. Well, did he make any attempts on your lower limbs? Again, this is 100-year-old language. Queen Victoria times, it was considered improper to use the word legs. So they just said lower limbs. Okay, back to the story. Yes, sir. And on your dress? Yes, sir. Miss Nellie Wood quit immediately and never went back except to get her pay for the 2 days. Miss Nellie Pettis gave testimony equally damaging. She told how Frank had leered at her, winked at her, showed her money, and finally asked, "What about it?" Miss Ellie's language was unusually vigorous. She told Frank to go to hell. In a Good Shepherd house in Cincinnati, Ohio, there is a poor girl who worked for Frank, and he ruined her. In a Florence Crittenden home in Georgia are 2 poor girls who worked for Frank, and he ruined them. How many other girls he ruined, he knows, but all that we know is that the state produced 11 more that he wanted to ruin. Mary Fagan was another. In parentheses, in the absence of the jury from the courtroom, Judge Roan allowed the girl from Cincinnati to tell how Frank had debauched her, and how unnatural his manner of satisfying his passion was, and she spoke of a scar on her inner thigh made by his teeth. To understand what sort of creature the evidence in the case proved Frank to be, you would have to read some treatise on moral degeneracy, such a book, for example, as Psychopathia Sexualis. End of parenthesis. Next subheading, had he lusted after Mary? Had this sensual beast lusted after Mary Fagan? Did he make indecent overtures? The record shows that he claimed not to know her at all. The point is immensely important. If he had known her and shown an inclination for her, it is a damning circumstance if he positively said, after she was found dead in his place, that he did not know such a girl and would have to consult his books. Next subheading, did he know her? Miss Ruth Robinson testified, I have seen Leo Frank talking to Mary Fagan. I heard him speak to her. He called her Mary. Miss Dewey Howell testified, I have seen Mr. Frank talk to Mary Fagan 2 or 3 times a day in the metal department. I have seen him hold his hand on her shoulder. He called her Mary. W.E. Turner testified, I saw Leo Frank talking to Mary Fagan on the 2nd floor about the middle of March. It was just before dinner. There was nobody else in the room. He stopped to talk to her. She said she had to go to work. He told her he was the superintendent of that factory, and that he wanted to talk to her. She backed off, and he went towards her, talking to her. Gant also testified that Frank knew Mary by name. Had you been a juror in this case, could you have disregarded all that evidence as to Frank's personal knowledge of the girl? Believing the witnesses and believing that he wanted to make her a fresher Rebecca Carson, whom would you have suspected of the murder when Frank brazened it out all the way through that he did not know that such a girl worked for him? Now at this point there comes an incident so natural in its occurrence and so peculiar in its suppression that I give it as a part of what happened. Frank had a cook named Nola McKnight. Narrator's comment, a black lady. Back to the story. And her husband worked for the Beck Gregg Hardware Company. This man, Albert McKnight, told 3 white men who were employed at the same place, the hardware store, of some queer things which his wife, the cook, had told him concerning what she had overheard in the Frank home. Narrator's note, this was on Saturday, when he had come home from the rape and the murder and trying to dispose of the body. And then she tried to, cook supper for them. And she overheard some strange conversations. Okay, back to the story. In consequence of what the cook's husband reported to the 3 white men, that is, at the hardware store where they all worked, Minola was taken into custody by the police in the hope of getting valuable testimony out of her. She was detained at the station house 2 days, during which somebody employed a lawyer to represent her. The upshot of the matter was that Minola, in the presence of her attorney, made a statement which was reduced to writing and sworn to by her before a magistrate of Fulton County. In his commutation of the sentence of Frank to death, the then Governor Slayton laid much stress upon McNola McKnight's affidavit, alleging in effect that it was entirely false. You have a right to view that statement of the cook in the light of all the surrounding circumstances, and to say how much moral weight you would give to it. For you are not bound by technical rules, and you are entitled now to know all that occurred. In order that you may have a clear idea of this episode, it is necessary to remind you that Frank had hurried Mrs. White out of the factory at about 1 o'clock, that Conley had gone on to his home, that Frank went out to his, and that Albert McKnight swears Frank remained only a few minutes, ate nothing, and hurried back toward the city. Albert told this to the white men he worked with at the Beck Gregg Hardware Company, and before his wife was arrested. It seems that this information, given by the cook's husband, was one of the first independent pointers to Frank as the guilty man, independent of the circumstances immediately surrounding the crime. At the station house, the cook, Minola, refused to talk to the detectives, but after these black sheep had been ignominiously sent away, the colored lady dried her eyes, composed her rumpled feelings, and spoke as follows. Mr. Frank came for dinner about 1:30, but Mr. Frank did not eat any dinner, and left in about 10 minutes after he got there. Mr. Frank came back to the house at 7 o'clock that night. Sunday morning I got there about 8 o'clock, and there was an automobile standing in front of the house. I didn't pay any attention to it. Parenthesis, it was the automobile of the 2 police officers. Close parenthesis. I called them down to breakfast about 8:30, and I found out that Mr. Frank was gone. Open parenthesis, the policeman had carried him with them to the car. I did not hear them say anything at the breakfast table. After dinner, I understood them to say that Mr. Frank and a girl were caught at the office Saturday. I don't know who said it. Mrs. Frank? Mr. Selig? Mrs. Selig? Narrator's note, the parents of the wife, Mr. and Mrs. Selig. And Mr. Frank were standing there talking after dinner when they said it. I understood them to say it was a Jew girl. This very remarkable statement of the cook would seem to prove 2 things. First, that she was not making up a tale, nor repeating one that her husband had made. And second, that the family of Frank was bandying to and fro the words Jew and Gentile, and the cook caught the word Jew and got it wrong. They were no doubt conversing in low tones, and the colored lady was probably listening at the keyhole. The mysterious automobile, the unusual absence of Frank from Sunday breakfast, and the general stir in the family could not have failed to arouse the colored lady's curiosity, hence her keyhole endeavors to acquire knowledge. The cook proceeds, On Tuesday, Mr. Frank says to me, "It's mighty bad, Minola. I might have to go to jail about this girl, and I don't know a thing about it." If the cook's husband invented this, he is a most extraordinary inventor. The cook proceeds, Sunday, Miss Lucille, that is, Mrs. Frank, said to Mrs. Selig, her mother, that Mr. Frank didn't rest so good Saturday night. She said he was drunk and wouldn't let her sleep with him. She slept on a rug on the floor. Miss Lucille said Sunday that Mr. Frank told her Saturday night that he was in trouble, and he didn't know the reason why he would murder, and told his wife to get his pistol and let him kill himself. Drinking so heavily that his young wife had to lie on the floor, tormented by recollection of what he had done, unable now to comprehend how he could have done that cruel, cruel murder, calling for his pistol that he might end it all. Such is the scene which rises before you as you reflect upon the cook's story. Invented? If so, whoever invented it should go to writing novels. A cook with that talent is hiding a big light under a small bushel. The cook proceeds, I haven't heard Miss Lucille say whether she believed it or not. I don't know why Mrs. Frank didn't come to see her husband, that is, when he was in jail, but it was a pretty long time before she would come to see him, maybe 2 weeks. Actually, it was nearly 3 weeks before Mrs. Frank would go to see her husband, a circumstance to which Frank's partisans never refer. In her affidavit, the cook swears that the Seligs paid her money and told her to be careful how she talked. Before the notary took her oath to her statements, she was asked, Has Mr. Pickett, or Mr. Craven, or Mr. Campbell, or myself, narrator's note that refers to the detectives and the police officers, influenced you in any way or threatened you in any way to make this statement? Answer, no, sir. Question, you make it of your own free will and in the presence of your attorney, Mr. Gordon? Answer, yes, sir. The cook signed her name and took the oath before G.C. February, That was the name of the notary. Notary public. The date was June 3rd, 1913. I venture to say that every white man who has an intimate knowledge of the characteristic of Negroes will agree that a Negro cook who has no grudge against her white folks could never have been induced to fabricate such a tale as Manola told. It is too circumstantial. It gives away inside facts which no human brain could have invented. It bears the earmarks of truth. What Negro would ever have drawn that gruesome night picture of the young wife lying on a rug on the floor, and the young husband drinking himself into stupefaction, wildly, wondering how he came to murder, and calling for his pistol that he might kill himself? The appearance which this distraught young man presented to the police officers the next morning was in exact accordance with his intoxicated condition the night before, as described by McNola McKnight. The evidence of the two white men, John Black and Woods Rogers, narrator's note, the police officers, tallies precisely with that of the cook, and they had given their description of Frank's appearance and movements on Sunday morning before they knew what the cook would later swear about his heavy drinking Saturday night. It is one of the most striking corroborations in the case. The cook told the truth in the affidavit, and if she lives until Frank dies, she will tell more. When the two officers went out to Frank's house, they had no suspicion of his guilt. They wanted him to see the girl, and if possible, give them some clue to work on. They found him in the nervous, jerky, rickety state natural to a man who had been drinking the night before. He asked whether anything had happened at the factory, and was told that Mary Fagan had been found dead in the basement. He makes no outcry of amazement and horror. He expresses no surprise at the crime. He utters no word of pity for the victim. He offers no information to the policeman. He suggests no possible theory as to the criminal. He closes like a clam, shakes like an aspen, begs for a cup of coffee, refuses to look on the pallid face of the murdered girl, and denies that he knew Mary Fagan. Narrator's note, the first sentence of that paragraph says, he makes no outcry of amazement and horror. He expresses no surprise. He utters no word of pity for the victim. Well, this is very important because what the police will do when they confront you and they know a murder's happened, and they will just throw the truth at you, and they're watching your face and listening to your voice and observing your body language as they throw this explosive news at you that a certain person was just murdered and we found the body. Because your reaction will tell them something. And so they're watching you like under a microscope at that second when they drop this bombshell news on you. And from their point of view, Leo Frank gave all the wrong signals. Back to the story. To the climax of the case, we come by a strong, continuous chain of evidence, furnished by white witnesses, not one of whom was impeached or contradicted, and not one of whom was unfriendly to Frank, if we exclude the girls he had tried to ruin. Consequently, it is impossible that you do not recognize in Leo Frank the man who had the lewd character needed in the criminal, the man who had shown a desire to possess this little girl, the man whose refusal to send her money made it necessary for her to come for it, the man who had her in his possession and power at the time she disappears, the man, and the only man, whom she asked about the metal room, and therefore the man, and the only man, who could have led her back there and shut the door without arousing her suspicion. It is impossible for you not to recognize in Frank the only man who had the opportunity which the metal room afforded when she asked the fatal question, "Has the new metal come?" He had accompanied the officers to the morgue and to the factory. He returned home and was there the remainder of the day, as far as the state knows. On Monday he was at the factory, where of course excitement prevailed. All that day, while Baird and the others were talking of the blood spots and the hair, and were casting about for clues, nobody mentioned Frank as a possible criminal. Nobody seems to have realized that he and Connolly were the only two men who could have killed the girl. It is highly probable that none of them knew that the doctors and the undertaker would testify that the body had been lifeless for so long as to carry the murder back to near the noon hour Saturday. These definite conclusions often ripen slowly, so slowly that we sometimes wonder at our own blindness not seeing them at first glance. When the scientific evidence fixed the time of the crime somewhere near the noon hour, and the girl's stomach corroborated the doctor's, the area of the investigation narrowed at once. The exact time that Monteith Stover was waiting in Frank's vacant office. Taking the time that Mary was seen going toward the building, and only 2 blocks distant, we were driven to the conclusion that she had entered and disappeared before Monteith arrived, and that she was in the metal room, unconscious, while Monteith was waiting in the vacant office. Frank's partisans have to contend that Mary left him at that time and went downstairs on her way out. If so, why was she not seen by Monteith Stover coming in, or on the street? But they contend that Conley seized her as he reached the foot of the stairs. Then how came the blood and the hair upstairs and not downstairs? And would not Monteith, entering, have caught Conley in the act? She would have caught Leo Max Frank in the act had it not been for the closed door of the metal room. Subheading: The blood on the floor. Pardon me for dwelling more at length on the blood upstairs on Frank's floor. What is the official record as to this blood? Police Detective J.N. Starnes testified, "I saw splotches that looked like blood, some of which I chipped up. I should judge the area around those splotches was 1.5 feet. It looked like a white substance had been swept over it. There was a lot of that white substance in the metal department." R.P. Barrett swore positively it was blood. The spots were not there Friday. The largest was 4 or 5 inches in diameter, with little spots behind these from the rear, 6 or 8 in number. Mrs. George W. Jefferson was another worker in the metal department. She swore, "We saw the blood Monday. It was about as big as a fan. Something white was over it. I didn't see the blood Friday. It was not paint." N.V. Darley, manager of a branch of Frank's factory, testified, "Mr. Quinn called my attention to the blood spots. Barrett called Quinn's attention to it. Barrett showed me some hair on a lever of the lathe. It looked like an attempt had been made to hide the blood spots. The white stuff practically hid the spots." What made the spots, and who tried to hide them? We narrow the investigation to Saturday, because 3 white witnesses swear the spots were not there Friday. The carpenters Harry Denham and Arthur White did not go to the metal room, and none of Frank's visitors did on Saturday, if we leave out Mary Fagan. If we accept Leo Frank and Mary Fagan, we were absolutely unable to trace anybody to the metal room on Saturday. Then, if the blood and the hair prove that at least 2 persons were in the metal room Saturday, and if the evidence excludes the possibility of those 2 persons being other than Frank and Mary Fagan, we are forced to the conclusion that those 2 went there, and if one of the 2 died by violence, we can't escape the conviction that the other did the killing. Of course, the state's theory is that when Frank struck the girl, her fall, backward and downward, was broken by the metal crank handle of Barrett's machine, and that its projecting shaft tore out some of her hair and ripped her scalp to the bone, inflicting the wound which ranged from down upward and producing unconsciousness. No other explanation can be given of 2 wounds simultaneously given, one in the face and the other on the back of the head. Now, Governor Slayton declared that the body could not have reached the basement by the elevator. What difference does it make? The corpse was in the basement, and there were no signs of a struggle in the basement, no signs of blood in the basement, no signs of torn-out hair in the basement. Nothing could be seen in the basement connected with the crime of violence. On the contrary, Sergeant Dobbs testified that he saw the trace of the dragging of the body, and this trace led from the elevator to where he found the girl. Her face was scratched and soiled in exactly the way it would have been had she been dragged by the heels. These surface abrasions of the skin were made after death, the doctor said, and there is no other way to account for them. So far afield have gone some of the mercenary theorists. Narrator's note, actually, Watson used the term Hessian to refer to the German mercenaries who were used in the American Revolution by the British against the Americans. But of course, when he says Hessian, he simply means mercenaries, people paid to say or do a certain thing. Repeat, so far afield have gone some of the Hessian theorists, the mercenary theorists, that they have argued the crime itself into the basement, where Conley, they say, held the girl's nose in a bank of cinders until she was smothered. Yet here is the official record, which shows that there was no accumulation of ashes or cinders in the basement, no ashes or cinders in the girl's nostrils or mouth, no ashes and cinders in her hands. The entire floor was just an ordinary dirt floor, gritty, of course, and with ashes and cinders sifted thinly on the surface and trodden into the earth. Narrator's note, Watson then attacks further the concept that Mary was killed by having her face pushed down into a pile of cinders, which, of course, there was no pile of cinders. It was just a hard dirt floor. So this is the first thing he's attacking. Now he's saying he's going after the real murder weapon. Back to the story. What more did the criminal need than the cruel cord tied around her neck in a running noose, a cord large enough and strong enough to strangle a horse? I have had that horrible thing in my possession, and I know what powerful twine it is. You could tie and hold a steer with it. As it was strangling the poor child, her tongue protruded from her mouth half an inch, and there was no bruise and no cinders on the tongue. No rapist or murderer could hold a strong girl's face buried in ashes and cinders and kill her that way, without leaving indelible marks in the ashes and cinders, without leaving indelible marks on the girl's front face, and on her neck, where his ruthless fingers gripped and held her. Is it not so? Upon this girl's neck was no sign of violence, save where the hemp cord buried itself in her flesh. No crueler mortal was ever instigated of the devil than the monster who roped that girl's tender throat and gloated over her as she died. How did her body get to the basement? It does not matter. Or if she went there well alive, neither Frank nor Conley could have carried her without the other knowing it, and if she went there dead, both were necessary for the work. Narrator's note, by the way, the word carried for Watson's prose means to lead somebody. So again, it says neither Frank nor Conley could have carried her, could have led her without the other knowing it, because obviously one would have to go down past the other to get to the basement. Okay, back to the story. There are only two ways of getting into the basement from the floor above. One is the elevator, and the other is the ladder. The foot of the ladder rests on the dirt floor, and it runs up to the hold, covered by a trap door. How large is this hole? It is 2 feet square. The witnesses said that one person at a time could pass through this hole in the floor and descend the ladder, but that it was a difficult matter. In other words, it was a tight squeeze for a grown man of average size to go down through this 2-foot hole in the floor. That being the size of the opening, and that being its location, you can readily see that it is an awkward, troublesome job for a full-grown person to go to the cellar in that way. With the elevator, it is altogether different. To use it with ease, nothing more was needed than to unlock the power box, and it was found unlocked Sunday morning. Consequently, whoever wanted to use it Saturday could do so, and the fact that it was found in usable condition Sunday naturally inclines you to believe that it had been in use Saturday. Is it not so? At all events, there was the elevator in condition to be used, with no other labor and difficulty than to open the door, step in, and pull the cable. The car would do the rest. But with the other way of reaching the basement, there was a trap door to be lifted, and a ladder, not stairs, a ladder, to descend. And when you give to any man the task of carrying a corpse weighing 107 pounds down that ladder, you have assigned to him a labor not only most difficult, but decidedly dangerous. The slightest loss of balance would have tumbled him off the ladder and imperiled his neck. Between the easy-going elevator and this hard-going ladder, which does your intelligence choose? Why not take the elevator? If my argument about the blood and the hair is sound, the elevator must be chosen, for you cannot suppose that the criminal toted the dying girl downstairs from the first floor. To have gone with her toward the front door, where a visitor was likely to enter at any time, would have been sheer madness. The elevator afforded secrecy, celerity, and noiselessness. No one could see what was in it, and no one could hear it, for the two carpenters on the fourth floor were not only engaged in the noisiest of work, but were 200 feet back from the elevator shaft. Even if there was some risk in the easy, swift use of the elevator, it was infinitely less of a peril than to lift the corpse and carry it down the stairway, and then get it through the trap door and down the ladder. Why should we not do what a criminal in such a case would naturally do? Follow the line of least resistance and adopt the safest, easiest, quickest method. Governor Slayton did not cross-examine Leo Frank or the accomplished Jim Conley, but the governor went to the factory and traveled up and down in the elevator, and after having done so, declared that Mary Fagan's body could not have been taken to the basement by the elevator. Why not? Because, as he says, on Saturday morning, a soft substance, excrement, had been deposited on the ground in the shaft, the elevator shaft, and this excrement was found unmashed Sunday. Wonderful, Governor. In the first place, the bottom of the shaft is uneven, and the elevator can rest upon the earth at one part and not touch at others. In the second place, elevators do not always stop at exactly the bottom. In the third place, the elevator did not mash the excrement when the policeman and Leo Frank first went down it on Sunday morning. Next subheading: the Jews first accused Frank. Let us go back to the Monday following the Saturday of the crime. The city of Atlanta was seething with excitement. The factory was in a hubbub. The detectives and the police were scouring the earth to find clues. Almost everybody suspected the night watch to be the criminal. He was put under arrest, and he was manacled. That's what the Gentiles did, at the instance of Leo Frank, who intimated his belief in Newt Lee's guilt. What did the Jews do? They stole over to the strongest team of lawyers in Atlanta and secretly employed them to defend Leo Frank. Be it remembered always that the rich Jews of Frank's immediate family and business connection were the first to accuse him of this hideous crime, before the Gentiles had said one word against him or taken any action against him. His own people had done what was never done anywhere at any time. They went out and hired the most expensive lawyers before there was a breath of Gentile accusation against this alleged martyr of, quote, race hatred, unquote. When you reflect upon this fact, your mind will connect it with the story which the cook told her husband. The Seligs, the parents-in-law of Frank, of course knew how Frank had raved that Saturday night. Their daughter would have been unnatural if she had not spoken of the horror which possessed her when that drunken husband was wildly talking of the murder and calling for his pistol. As sure as God made the world, the Seligs communicated with the Montags and the Haas brothers that very day. The police had gotten them, too, on the phone just after finding the corpse, and they hot-footed it to the law firm of Rosser and Brandon, a firm soon to be augmented by the governor-elect, John M. Slayton. Keep this detail in mind. Now consider the phenomenal situation. There lies Mary at the morgue. There sits Newt Lee in jail with handcuffs on. There go Barrett, Stanford, Mrs. Fleming, and others, showing the blood and the hair. There goes Jim Conley, about his work as usual, the same clothes he wore last Saturday. There goes Leo Frank, who has changed his clothes, who tells the police that he doesn't believe that the night watch has told all he knows. And there goes somebody to plant a bloody shirt in the night watchman's clothes barrel. And somebody fixes a time slip which gives Lee time to have gone to his home during the night of the crime. And this is done after Frank had told the officers the time slip was regularly punched. and it is Frank himself who, after the bloody shirt has been planted on Newt Lee's premises, urges the police to search those premises. And during all that time, the best lawyers have been secretly engaged to defend Leo Frank, lawyers who will soon take into their firm the man whom the people had recently elected to be their chief magistrate. When the detectives lose faith in the bloody shirt, there was no African odor on it, and the blood was too evidently a recent smear inside and out. Frank has another shot in the locker. He tells the officers that J.M. Gant had been intimate with Mary Fagan, and hints that he had been too intimate. He also informs them of Gant's visit to the factory Saturday afternoon to get 2 pairs of old shoes he had left there. Consequently, the excited police go and nab J.M. Gant. Thus, the martyr of race hatred flings the meshes of suspicion around 2 innocent men before he himself has been suspected by anybody, excepting the rich Jews who had swiftly, stealthily employed for the martyr the supposedly ablest lawyers in Georgia. And so thoroughly uneasy are these rich Jews that the governor-elect is soon added to the Rosser firm, to the amazement of the political friends of John M. Slayton. To be exact, Rosser took the governor-elect into his firm in May 1913. Mary Fagan had been killed in late April. To fully comprehend the infamous betrayal of the state of Georgia by Governor Slayton, you must keep in mind the astounding fact that he joined Rosser's firm after that firm had been employed to defend Frank and had publicly taken part in his case. If an angel from heaven should swear on a stack of Bibles that Slayton's partnership with Frank's leading lawyers had nothing to do with this commutation of the sentence, you might possibly believe it. Now, a governor cannot practice law openly, and in June 1913, John M. Slayton was to be inaugurated for a term of 2 years. Why, then, did he in May join a firm with which he could not openly act until after June 1915? And why did Rosser, in May 1913, take in a partner whom he could not openly use during the next 2 years? Mark this. On Monday, Jim Conley and Frank came and went. Lee and Gant were in limbo. Others were suspected and temporarily detained, and still not a word was said against the Jew. His battery of lawyers was masked. Nobody knew such a battery had been positioned. His Montags lay low. His Saligs were equally discreet. Suddenly, like a scene shift on the stage, the officers turn to Leo Frank and say in substance, "We will have to interrogate you, Mr. Frank." Then the legal battery unmasks. Frank refuses to answer any questions until his Rosser comes. Innocent? When did conscious innocence ever play the game with trump cards up its sleeve? The crafty Frank knew from the first that the dogs would find his trail sooner or later, and he had not only prepared for the struggle by retaining crack lawyers, but he had kept suspicion off Jim Conley, not even informing his detective Harry Scott that Conley could write. And if Conley was guilty, Frank was. The thing is plain enough. Put Conley at the foot of the stairs, and Frank at the top, and the girl going up or down the stairs, it is impossible for one of the men to seize the girl and do what was done to her without the other man knowing it. The doors were open between Frank and Conley. The space separating them was inconsiderable. Conley could not strike the girl in the face and knock her down without Frank hearing it, whereas Frank could go with her back to the metal room and close the door. Because of the certainty that if Conley committed the crime, Frank knew it, Harry Scott and the police officers made every effort to find the criminal in somebody else. Only as a last resort did they turn to Conley. Reluctant to betray his boss and get himself in trouble, Conley denied all knowledge of the crime and went to pouring out lies in true Negro style. But the conviction grew that only he and Frank could be implicated, because only they had had the opportunity. Finally, the Negro broke down, confessed, and asked to be taken to Frank so that the two could be heard to talk the matter over. And the innocent martyr, a graduate of Cornell, shrinks from meeting the ignorant Negro in the presence of witnesses. Yes, the white man is afraid to face the black, who accuses him of the most heinous crime ever perpetrated in the South. What was Frank's excuse for not facing the Negro and talking with him about how the little girl came to her death in his place of business? His excuse was that Rosser was out of town. But Haas was not out of town, and Rosser's partners were accessible. However, the innocent martyr dared not confront a guilty Negro, a, quote, low-down drunken brute, unquote, they call him, because Rosser was not present to prevent the black brute from getting the better of the educated white gentleman who was president of the Atlanta B'nai B'rith organization. And this is the same shrinking, cowering culprit who could not look at the dead girl's face, pretended not to know her, feared to ask the 11 white ladies why they swore he had a lascivious character, and hid himself behind his legal immunity from cross-examination. This is the victim of mob spirit and race hatred, this Jew whose rich kinsmen stealthily hastened to hire lawyers before any Gentile had accused him, and whose Jewish wife utterly refused to go to him for 3 weeks after his arrest. There are some actions that speak like thunderclaps, and the secret employment of those lawyers, together with the abhorring avoidance of Frank by his own wife, are just such actions. How in the name of God can any sane man believe him innocent after weighing those two stupendous facts? The Jews closest to him condemned him before the Gentiles even suspected him. It was not until the 29th of April that Frank was detained at police headquarters to await the action of the coroner's jury. After a careful investigation of the case, Frank and Newt Lee were both held. Frank had testified at length under oath, and not one word of suspicion had he dropped on Jim Conley. He did not tell the coroner that Conley was in the factory on Saturday, nor did he disclose the fact that Conley could write. He did not utter a word that would clear Newt Lee and give to that innocent darky his freedom. He was perfectly content to screen Jim Conley and see the halter close upon the neck of Lee. On May 24th, Frank was indicted by 23 grand jurors, 4 of whom were Jews. Not one of those official accusers has ever asked that Frank's sentence of death be commuted. On July 28, 1913, Frank's trial commenced before Judge L.S. Roan and a jury selected jointly by the state and the accused. Until August 20th, the court was hearing the evidence, and on that day the attorneys began their speeches. 5 days later, the case went to the jury, and on the same day a verdict of guilty was returned, without recommendation to mercy. On the next day, Judge Roan sentenced Frank to be hanged on October 10, 1913. His attorneys moved for a new trial, which Judge Roan refused, and the case was appealed to the Supreme Court of Georgia, which affirmed the court below. The Supreme Court reviewed all of the evidence at great length and decided that it was sufficient to sustain the verdict. This decision appears in the 141st volume of Georgia Reports and speaks for itself. 4 of the 6 justices held that the trial of Frank had been perfectly fair and that he had been properly convicted. 2 of the justices differed and held that Judge Roan should not have permitted Conley and several white witnesses to testify to the independent acts of immorality on the part of Frank. The decision as published shows that this was the only question upon which our Supreme Court divided, and you can see that it was a point of minor importance. The real issue in the case was whether Leo Frank murdered Mary Fagan, for the indictment did not charge him with rape. Consequently, Justices Fish and Beck went off on a spur track and did not jump the rails on the main line. No matter how immoral the jury believed Frank to be, they were too intelligent to convict him of murder on evidence of sexual vices. It is well for you to know what the Supreme Court divided on, because the public has had the fact of the divided court dinned into its ears for more than a year, without having been told the comparative insignificance of the division. Neither has the public been told that when Frank's lawyers took the division of the justices too seriously and demanded a rehearing of the case, the Supreme Court unanimously refused it. This of itself proves that the dissenting opinions of Justices Fish and Beck left no deep impression even on their own minds. With an effrontery hard to comprehend and sufficiently condemn, it has been stated again and again that the state of Georgia has no court that can review the evidence in a criminal case. Every volume of our Supreme Court decisions, the Georgia reports, proves the audacity and shamelessness of the falsehood, first published by journalist C.P. Connolly and finally by the governor who commuted the sentence. So far is the statement from being true that in practically every motion for a new trial, there are three stereotyped grounds which are argued before our Georgia Supreme Court, to wit, that the verdict is against the evidence, that the verdict is against the weight of the evidence, and that the verdict is unsupported by the evidence. While, of course, these three stereotyped grounds are really but one, the fact that they are almost always made and passed on by the Supreme Court shows that this highest of state tribunals is constantly reviewing the evidence, weighing it, measuring it, and deciding whether it shows the defendant's guilt beyond a reasonable doubt. If, in the opinion of the court, the evidence fails to do this, the judge below is reversed and a new trial ordered. When C.P. Connolly stated in Collier's magazine that the Supreme Court of Georgia had no such power as this, it was possible to explain his mendacity upon the assumption of his ignorance. But when Governor John M. Slayton used almost the same words in saving the neck of his guilty client, no such excuse can be made for him. He lied with deliberation and moral turpitude. Narrator's side note: turpitude comes from a Latin word, and it means something extremely base and evil. Back to the article. On page 247 of the 141st volume Georgia Reports, you may read the 20th headnote of the Supreme Court's decision in the Frank case. 20. The evidence supports the verdict, and there was no abuse of discretion in refusing a new trial. In the body of the decision, page 284, you may find these words. 20. The record is voluminous. We have given careful consideration to the evidence, and we believe the same to be sufficient to uphold the verdict, and as no substantial error was committed in the trial of the case, the discretion of the court in refusing a new trial will not be disturbed. In two other cases reported in the same volume, the Supreme Court was asked to review the evidence against the defendant and to decide whether it showed guilt beyond a reasonable doubt. The cases are those of Brown and Hart, both murder cases, and the court held that the evidence must demonstrate the guilt of the defendants beyond a reasonable doubt. That is a maxim, a standing rule, an invariable principle with our Supreme Court, and every Georgia lawyer knows it. Next subheading, Enter Burns. The decision of our highest court was supposed to settle the Frank case. Such a decision has always been taken as final, except in extraordinary cases where new evidence developed after the trial, evidence which might have caused a different verdict, and which could not have been discovered before the trial by the use of diligent methods. Here it was that Burns came roaring into the case, airily assuming that it had never been tried. Burns blotted out the trial judge, the jury, and the Supreme Court. Burns made a calliope of himself, and every resounding note he struck echoed deafeningly throughout the Atlanta dailies and throughout the northern newspapers owned by the Jews and by William Randolph Hearst. Burns ostentatiously visited the pencil factory, just as though he had recently discovered its whereabouts, and he sleuthed over the premises with unearthly skill and subtlety, just as though the crime had been committed the day before. After running up and down the stairs, and poking his nose first in one room and then in another, and traveling back and forth in the elevator, and cannily boring holes into everybody with his all-knowing eyes, Burns came forth to the reporters and yelled into their eager ears the startling discovery he had made. He had discovered, the blatant ass had actually discovered, that the crime was the work of a pervert of the lowest type, and this pervert was a man that no one had even suspected. He, Burns, meant to locate that unsuspected man, demonstrate his guilt, and overwhelm the rival Pinkerton Detective Agency and the Atlanta police. He, Burns, was utterly confident. He would lay his hands on this unsuspected pervert, and by proving his guilt, Burns felt sure he would confess, he would show what boobies the Pinkertons and Atlanta police had been when they arrested Newt Lee, J.M. Gant, Jim Conley, and Leo Frank. Never in my life have I known any man to make as much noise as Burns made, and never have I known the daily papers turn themselves into sounding boards, foghorns, and megaphones for anybody as willingly as they did for this empty, vociferous, and pestilent scoundrel, William J. Burns. There is just this much to be said to the credit of his intelligence. He then saw the same thing that Harry Scott had seen, to wit, he couldn't implicate Jim Conley at the foot of the stairs without implicating the white man at the head of the stairs. Burns saw what any sane man ought to have seen, that the crime could not steer clear of both the white man and the Negro when they were so close together, and each knew of the other's presence, and each knew of the presence of the girl. If she left Frank, she went to Jim, but almost in Frank's presence. If she did not go to Jim, she never left Frank. Even an asinine pseudo-detective like Burns could see that. The only people who do not see it belong to the class who, having eyes, see not. Burns knew that Frank, if innocent, would have said at the very beginning, "The girl must have been assaulted and killed almost immediately after she left my office. And as nobody but Jim was at the foot of the stairs, Jim did it. Go and nab Jim. Don't bother with Newt Lee. Don't arrest J.M. Gant. Don't search Lee's premises for a blood-stained garment. Seize Jim. Search his premises. Jail the woman he lives with. Question them, and separately compel Jim to tell what became of Mary after Mary left my office, for she never reached the door. She was stunned, assaulted, and strangled inside my place. Jim and I were the only men in the house who could have known the girl was there, and who could have made the attack on her, and as I did not do it, Jim did." Oh, gentlemen, use your common sense. Isn't that what you would have said had you been where Frank was, and none of that little maiden's blood reddened your hands? What's the use of publishing falsehoods about Georgia laws, Georgia courts, and the Georgia people, when one of our children lies in her untimely grave, and the record evidence so plainly proves the infernal guilt of the man whom Rosser's partner, John M. Slayton, rescued from biblical punishment? Burns knew that had Frank been innocent, he would have put Harry Scott and the other officers on the trail of Jim Conley instead of Newt Lee, and Frank would have told the detectives that he recognized Conley's writing in those notes, that it was Conley who must have grabbed the girl as she reached the bottom of the stairs. Burns isn't altogether an nincompoop, and he therefore knew that the screening of Jim Conley by Leo Frank meant exactly the same as the screening of Leo Frank by Jim Conley, to wit, that they were both guilty. Consequently, Burns went roaring up into the north to find his pervert, quote, "who is still at large," unquote. There is evidence in the record which shows that Burns tried to make a dummy out of a Chicago darky named Allen. It appears that Burns pretended to be mysteriously turning the earth over in Cincinnati. From time to time, Burns vigorously smiled upon mankind and foghorned the information that he was making, quote, "most gratifying progress," unquote, in his sleuthing after that elusive pervert who had never been suspected. We were told that Burns was compiling a mighty document as he went along, and this dynamic document, as he vociferously shouted, would clear Leo Frank. Naturally, Burns got on our nerves. He stayed there. We became obsessed with Burns. He agitated our reflections, disturbed our digestions, and monopolized our dreams. I never saw anything like it. The expense account of the Haas Finance Committee would, in my judgment, be more interesting than any human document that could be found this side of Jerusalem. But all things must have an end, and even the Burns peregrinations and vociferations had to reach their final showdown. And when Burns' famous report came into view, it was nothing in the world but another argument, and a sorry one, on the evidence in the record. Whichever way he turned, Burns ran into an impassable wall. It was the resource of desperation when they fixed upon Conley as the only criminal. They did not do it until there was nothing else to do. And they could never have got away with it if Rosser had not had a partner in the executive office. Narrator's note, meaning in the governor's mansion. Next subheading, what about the mob? In his very long and very incoherent defense of himself, Governor Slayton urged the importance of what he called some newly discovered evidence. That trumped-up stuff was made on the basis of an extraordinary motion for a new trial, and when Judge Benjamin H. Hill overruled it, the case again went to our Supreme Court, which unanimously decided against the defendant. Not until he had twice gone to the highest state court, with nearly 200 different assignments of error, did Frank raise the point that he was not present in person when his lawyers waived his appearance and received the verdict. Judge Roan knew of the intense but repressed feeling in Atlanta, and he feared that this feeling might escape control if the defendant were acquitted. Suffering from the cancer which took his life not long afterwards, and worn down by the terrific strain of the trial, Judge Roan was naturally nervous and apprehensive. But as a matter of record, it was proved that he had nothing tangible to base his anxiety upon, for the sheriff, who has for cause been Frank's champion, testified that there had never been any disturbance, no mob threats, etc., and a score of deputies and other citizens swore to the same thing. No evidence to the contrary could be obtained. Remember in this connection that ex-Governor Brown, in his statement to Governor Slayton, said that certain gentlemen had brought to him vague rumors of an intended mob, and that on the strength of these vague rumors, he had requested that some of the officers and soldiers of the National Guard sleep at the armory that night. Ex-Governor Brown further stated that he caused the mayor to have the city scouted in automobiles, that there was absolutely no sign of any mob anywhere. Not as many as 3 men could be found bunched together. Therefore, all the wild talk about mobs and the holding of the military in readiness frittered away into, quote, vague rumors, unquote, which led the governor to request that a few soldiers sleep where they could act quickly if needed. The lawyers of Frank made out a narrative of mob demonstrations and mob pressure, drawing upon their imagination with prolific liberality. They carried this before Judge William Newman of the federal court on a writ of habeas corpus, which took the defendant out of the custody of the state. Losing before the Atlanta judge, the lawyers persisted until they got the case before the Supreme Court of the United States. On April 19, 1915, a decision was rendered against Frank, 7 of the justices holding that all the alleged facts as to mob violence had been carried before the Supreme Court of Georgia and had been considered by that court, quote, at times and places and under the circumstances wholly apart from the atmosphere of the trial and free from any suggestion of mob domination or the like. And the facts were examined not only upon the affidavits and exhibits submitted in behalf of the prisoner, but also upon the rebutting affidavits submitted in behalf of the state, and which, for reasons not explained, he has not included in his petition. End of quote. The 7 justices, therefore, held that, as Frank's lawyers had failed to include in their pleadings the evidence upon which Judge Hill and our Supreme Court had based their decisions, the United States Supreme Court must assume that the Georgia courts had reached a righteous decision on the question of mob violence. The 7 justices of the United States Supreme Court evidently suspected that the counter-showing as to the existence of the alleged mob violence at the trial must be conclusive, else Frank's attorneys would not have been afraid to let the court and the country see how crushingly the state replied to those belated and manufactured charges. The 7 justices cited numerous cases in which our Supreme Court had granted new trials because of mob violence. And one of these was that Will Myers the Jew, who brutally murdered Crowley near Atlanta, and who made a suspicious escape from the jail. If alive, he is yet roaming the earth, a free man, in consequence of the extreme jealousy of Georgia's highest court in seeing to it that even the guiltiest wretch shall be given a fair trial. But it is said that 2 justices of the United States Supreme Court dissented. So they did. But upon what? Justice Holmes, speaking for himself, and Justice Hughes, took the entire statement of Frank's lawyers as true, prima facie, and taking it to be the truth, those members of the court held, quote, "Upon allegations of this gravity, it, that is, Frank's petition, ought to be heard," unquote, by the federal courts, although it had already been heard and decided by the state courts. Justices Holmes and Hughes held that it was proper to decide against the state without seeing the state side of the case, and to treat as null and void a state court decision because of an ex parte attack upon it. Narrator's note, the Latin legal term ex parte means an attack by just one side in the trial, such as the state, or an attack on the verdict by the defendant, the prisoner. That would be ex parte. One side only complains. I don't think many good lawyers will accept that as good law, and such a principle certainly antagonizes all previous decisions. The 7 justices merely followed precedent. To have ordered the retrial in the federal courts of an issue of fact, which the state courts had already tried and decided adversely to the defendant, would have been revolutionary. Narrator's note, what Watson is saying here with the phrase an issue of fact is that the Supreme Court has the responsibility to judge on mostly matters of law and procedure. Was the trial fair? Was the judge fair? Was the jury fair? Or are the laws passed by Congress fair? Do they obey the U.S. Constitution? He's saying that since the federal court, nobody disputed the evidence, that lots of good evidence was introduced at the trial and discussed, then so it's not an issue of fact, then what's the problem? If the evidence was fully discussed and heard by the jury and fully laid out and discussed by the prosecution and the defense, and there were no problems with the trial, then there's no reason for the Supreme Court to rehear the case, neither on the facts nor on the law, neither on the evidence nor on how the trial was conducted. But it is sufficient to remind the unprofessional reader that Justices Hughes and Holmes went no further than to decide that, taking the allegations of mob violence to be true, Frank had a right to be heard on that point, and the professional as well as the unprofessional reader will be surprised to learn that Frank had been fully heard on that very point, that the record shows that there wasn't a particle of merit in that point. Why? Because there was no evidence to support it. Next subheading, the facts about Conley. You will have noticed that I have discussed the case upon the testimony of the unimpeached white witnesses, without using Jim Conley at all. Let us now consider the Negro, who has been so widely and violently assailed by the Frank partisans. What are the facts, as shown in this official record? They are that Conley has been continually at work for white men in Atlanta, and that he never had any trouble with any white person. Nor was he ever a convict, except for 30 days when he was sentenced in the police court for fighting another Negro. In 1904, Jim had a row with a darky and was fined $1.75, which he paid. In 1905, he paid the same fine for the same luxury. In 1906, they raised the price on him and fined him $3.75, which he paid. In 1907, he had 2 fusses and paid $26 for the brace. Finally, in 1912, he was given a sentence of 30 days. At that time, he was in the employ of Leo Frank. There is no evidence that he had ever been accused of violating a state law, much less convicted of any crime. narrator's note, as opposed to a county ordinance having to do with fighting, or crime as opposed to a misdemeanor, drunkenness, fighting, small things like that. By crime, Watson means a felony. The record shows that Conley had been a steady, regular worker at the pencil factory for 2 years. In that length of time, Frank and his associates had found no serious fault with the Negro. He was accused of borrowing nickels and dimes, which he was slow to repay, and one gentleman who had occasion to send Jim for a pot of beer swore he wouldn't believe Jim on oath. Quote, "I have had no confidence in him since he put water in my beer." Unquote. So you see, it's really nothing of importance that they could prove against the Negro, and you may be sure they left no stone unturned. Then, what is the gist of this evidence? It is that he saw 2 girls go upstairs and only one come down. Mary went first, and Montine followed, and Montine remained upstairs quite a little bit, and then came back down and went away. That he had already heard steps like 2 persons walking back to the metal room just before Montine came in, and that after Montine left, someone came running to the front upstairs on tiptoes. Then he heard the stomp that Frank always made when he was signaling Jim about a woman, and that he answered the signal and found Frank near the head of the stairs, looking wild and excited, and that Frank asked him if he had seen a girl come upstairs, and Jim answered, "I seed 2 go up, but I ain't seen but 1 come down." Then Frank told him that he had tried Mary in the metal room and that she had resisted, and he had struck her, and, quote, "I guess I hit her too hard," unquote, and that she had struck something and fell. Frank told the Negro he must help get the body to the basement, and the Negro went to where the girl was lying on her back, with hands and arms up. Frank had torn a strip from her underclothing, had folded it, and had placed it under her head, and that blood-clotted piece of undergarment had its tremendous weight with the jury, for it accounted for there being no blood on the floor beneath the hair, on the lever she had struck in falling. Jim picked up the body, narrator's note, a 107-pound body. She was not a little baby. She was, 107 pounds is a lot. Unless you're a very strong man, that's a lot to carry, and it's not like carrying barbells. A human body will flop around, and it's loose, and arms and legs. It's harder than carrying a mattress, that's for sure. It's unruly and unwieldy to carry a body. Firemen are trained how to carry people, but Jim was not a trained fireman. So it says here, Jim picked up the body, carried it a few steps, and dropped it near the dressing room, and the blood spattered as her head again hit the floor. Frank had to help Jim with the body, and they carried it to the elevator, the key of which Frank hurried to his office and got. They took her to the basement and left her right there by the elevator, from which Sergeant Dobbs afterwards saw the signs of dragging commence. Frank was so excited, narrator's note, by that Watson meant agitated, that he ran up the ladder, telling Jim he would catch the elevator as it passed him on the floor above. This he did. Then they were in Frank's office, and Frank talked excitedly, ramblingly, and all at once exclaimed, "Why should I hang? I have rich people in Brooklyn." Now at that time, and at the time Jim told the police of this, the Negro did not know that Frank had any wealthy kinspeople anywhere. Then Frank asked Jim to write the notes. Narrator's note, the infamous death notes that supposedly Mary Fagan wrote as she was being raped, blaming the night watchman. Okay, repeating. Then Frank asked Jim to write the notes, and the Negro wrote 4, 2 of which seemed to suit Frank, and he put them all in his desk. He gave Jim money, but took it back, saying he would attend to that later. He outlined a scheme by which the Negro was to take the crime upon himself, promising to get him out on bond, and spirited him away. He made Jim promise to return that afternoon and help him to dispose of Mary's body. Then they left the building, Jim going for a drink of beer in a nearby saloon,
and then walking homeward with Ivy Jones. At home, Jim got to thinking about what had happened, and he was afraid to go back to the factory. Nor was he there Sunday, but he turned up as usual Monday morning. In the 2 notes found lying beside the dead girl, she was made to tell her mother who it was that attacked her, and to explain how her body got to the basement. She said that as she went to the toilet, Frank's floor toilet, the night watchman seized her and flung her down the scuttle hole. Notice the wild confusion which raged in the mind of the real author of the notes. He puts the place of the deadly assault right where it occurred, but postpones the time of the crime until night, when Newt Lee, narrator's note, the night watchman, will be on duty. He doesn't realize the difficulty of explaining how Mary was kept in the building from about noon until dark. But he does realize that he must try to account for the corpse being in a place the girl had never entered. So, in one breath, he put the girl at the toilet, near the blood and the hair. And in the next, he has her flung down the ladder into the basement, where no blood and no hair could be found. Now, if you can believe the blood and the hair made their way perversely from the basement to near the toilet, narrator's note, the 2nd floor, to which, as Frank told the jury, he might have gone unconsciously, you may also believe that a Negro, having committed the crime, seated himself by the corpse in a dark cellar to write notes of explanation to the girl's mother. Robust animals like Connolly do not commit the crime of Sodom. Narrator's note, Watson is referring to anal sex. Continuing. That is the vice of the degenerate, and Leo Frank's face looks the part to perfection. Consequently, such a robust and natural Negro as Connolly would be almost the last man you could imagine as the author of the notes in which unnatural intercourse with that little white girl is suggested. Now let us put our mother-wit to work on this Negro witness. When the record discloses that he had worked 2 years for Leo Frank, we must assume that a certain intimacy and confidence had been established between the two. When we learned from disinterested white witnesses that Frank had had women of the town to visit the factory during business hours and on Saturday afternoons, we are bound to believe that the Negro knew of it because his place was near the front entrance. Wouldn't Frank, who was afraid of his Uncle Montag, want someone to keep a watch out for him when these lewd women darted in and out? Naturally. Then who would serve his purpose better than this submissive Negro? But let us come directly to the question which goes to the bowels of the matter. What evidence did the state have on Jim Connolly when he at length broke down and confessed? The state had none, absolutely none, except that 3 outsiders had seen a Negro whom they did not know occupying a seat where Jim usually sat. In other words, the state had no more evidence against Jim than it had against Frank, to wit, that he was in the factory on Saturday. Therefore, when the Negro confessed, he gave evidence which the state had been unable to get, and if he had kept his mouth shut, Newt Lee might have suffered. After all, the dead body was found where Lee alone had been for 9.5 hours, and the forged time slip did show a gap of an hour, and his clothes barrel did hold a blood-stained shirt which might be his. Therefore, excited minds might suspect his guilt, especially if the person who planted that shirt would also swear he saw Mary Fagan on the streets Saturday afternoon. Narrator's note, what that last sentence means is, if Mary Fagan was seen on the streets Saturday afternoon and was not murdered at around noontime, she then would have gone to or toward at least the Confederate Memorial Day parade, and so she was hanging around in downtown Atlanta, later on, getting toward the time when Newt Lee at 4 p.m. would come on duty as the night watchman at the factory. So Leo Frank is basically saying, Mary was still around at 2 or 3 or 4 o'clock in the afternoon, and I saw her on the street. Well, okay. Then maybe Newt Lee could have seen her and killed her, but we know the fact is that Mary Fagan had been dead for hours by the late afternoon. Okay, back to the story. That Frank and his partisans were dead set against the innocent Newt Lee is shown by their desperate effort to prove by a prostitute that she passed the pencil factory Saturday afternoon and heard a woman scream. Remember that all of this horrible work against an innocent Negro was in full progress at the time Conley made his confession. In other words, Newt Lee, the one accused in the notes, was being framed by Frank and his lawyers. Conley blocked the hideous scheme by his confession. Narrator's note, we see once again that Watson is trying to show there was a certain amount of decency in Jim Conley. I mean, his various little misdemeanors had been fighting with other black folks. Later on, after all this happened, after the trial, after Leo Frank was lynched, later on he burglarized a liquor store and did some time. But, he really didn't commit any serious violent crimes. And we know also that when he found the body of little Mary Fagan with her little hands up in the air in the act of trying to fend off her rapist, he felt a piety and natural sorrow and regret and pity for this little dead girl, and he pushed her already stiffening hands and arms down and folded them over her breast, so showing sort of respect for the dead girl. And we see in this case, as Watson is pointing out, Conley didn't want to see Newt Lee hang for a crime he had not committed. I might add that in Mary Fagan Keene's book about the case, and Mary Fagan Keene is the great niece of Mary Fagan, and actually looks a little bit like her. She relates how in the 1930s, 20 years later, Jim Conley actually traveled to the home of the Coleman Fagan family to meet with the mother of the girl and the stepfather, John Coleman. And I guess he wanted to unburden himself and talk about that day and what had happened. And John Coleman listened to him talk and thanked him for coming and said, "If I thought you had murdered little Mary, I would strike you dead as you stand here." So there was a sense that Jim Conley, he was certainly no angel, but Jim Conley did have some decency. And the fact that he would go visit the family of the bereaved shows that he did have a conscience and regretted very much what had happened. Remember also that Haas, the lawyer, narrator's note, the Jewish lawyer, the word means rabbit in Yiddish, Haas, end of comment, and Montag, the principal owner of the factory, had both been told over the phone by the police of the same finding of the corpse, told at the same time that the policemen were persistently trying to get Frank on the phone. They could hear the phone buzz and ring at the other end, but no response came from Frank's house. Narrator's note, what Watson is saying here is that the lawyer for Frank and Montag, the owner of the pencil factory, who was the boss of Leo Frank, were already busy at work on something here, indicating that Leo Frank had already been in touch with his lawyer and with his boss, the owner of the factory. So they were working hard. They were all these Jews were working hard on framing Newt Lee. And Newt Lee, the night watchman, was totally innocent. In fact, he's the one that called the cops. And they were certainly willing to see this innocent Negro be executed. And we have to remember that the heyday of lynching in the South was from around 1880 to 1920. And so this was 1913. It was right in the middle of the, so to speak, the golden age of lynching. And so there was a real danger that Newt Lee would be possibly lynched, but definitely he would be executed if a trial convicted him, or if the public had decided that he was guilty of raping and murdering that beautiful little white girl. So, Newt Lee was in great danger. I mean, there was no tolerance for black men raping little white girls in the Deep South 100 years ago. Now another thing. Suppose the undenied facts are inconsistent with the theory that any Negro committed the crime. Did any black assailant of a white woman ever go looking for a cord with which to strangle her when his fingers were already on her throat? Never. Did any black assailant of a white woman ever choke her to death and then reverently fold her hands across her breast? Never. Did a black rapist and murderer of a white girl ever seat himself near her to write 4 notes to her mother? Never. Did such a Negro criminal ever return to the scene of his crime and go about his work as usual? Never. Then the conclusion which fixes itself in your mind is that whoever used the cord was not a Negro, and whoever folded those pulseless hands across the child's bosom and wrote the notes to her mother was not the principal perpetrator of the crime. And if the Negro afterwards came and went about the premises as if nothing had occurred, he did not assault the girl. Let us view it from another standpoint. If there are undisputed facts in the case which cannot be explained outside of Jim Conley's testimony, are we not safe in taking his evidence to that extent? The undisputed facts which cannot be cleared up without the aid of the Negro's story are these. 1. There was no blood on the floor under the bench lathe where the hair was found. 2. There was blood a few steps distant in the next room. 3. There was a cloth stained with blood hanging loosely around the girl's neck. 4. Her hands were decently crossed upon her bosom, and so rigidly fastened there that they did not fall apart when the corpse was dragged by the heels 125 feet over a dirt floor which scarified her face. Narrator's note, first of all, I think it's just horrific that the body of this beautiful little girl was just dragged along the basement floor. I mean, at least Frank could have helped to pick her body up and carried her, but I guess he was a weakling or something, and 2 men couldn't carry a 107-pound girl between them, so they just dragged her. I really resent that. The Negro told the jury how he found Mary's body with a piece of cloth under her head, quote, like to catch the blood, unquote. The jury saw the cloth, and the jury knew that no black man ever killed anybody and then folded a strip of cloth torn from the dress to catch the blood. If not used to soak up the blood, why was the cloth loosely tied around the head? What Watson is saying here is that somebody, not of the black race, somebody he felt who was sophisticated, had come up with this scheme to tear some absorbent clothing, like undergarments, cotton undergarments, something that would soak up blood, and then wadded it up to make a pad, and then put this pad under the dead girl's head to catch the blood. So Watson is saying somebody who was brighter and more sophisticated than Jim Conley had to do it. And he's, of course, implying Leo Frank. The Negro explained how he dropped the heavy corpse in passing the dressing room, and thus spattered the floor with blood. The Negro told the jury quite simply, and without knowing the vast psychological value of his statement, that he, quote, put her hands down, unquote, and folded them across her bosom. Did any man ever do that for any victim of his lust? Never in God's world. Narrator's note, I think Watson's making a really important point here. It just shows the brilliance of Thomas Watson
and his 25 years of experience as a trial lawyer, and he dealt with quite a few murder trials. Any man who is going to sock a girl in the face to the point that her head flies back against a metal machine and knocks her out, and then proceeds to vaginally and anally rape her while strangling her with a cord, hates his victim, is angry at the victim for initially refusing him, and has just murdered the victim, clearly in a fury. Such a person in such a state of mind and attitude is not going to reverently place her little hands over her breast, in the traditional position of repose of the dead, such as you'd see actually in some of the coffins of the kings of England in the cathedrals. They have their hands folded like an X over their chest. This is a sign of reverence for the dead. So I think Watson's making a very important point here. Back to the story. Now, when you consult the evidence of other witnesses and find that the girl's arm remained in that position as she was being dragged on her face, your intelligence drives you to the conclusion that her arms became rigid in that position long before she was dragged. Then you are pushed back to the story the Negro told, the story of Frank's calling to him for help, the cloth under the bleeding head, the carrying of the corpse to the elevator, the leaving of it on its back in front of the elevator shaft, with the arms crossed, as Jim had put them, upstairs. Take Jim's story, and every kink untangles, every crease smooths out. Reject it, and there are undisputed facts in the record which no human ingenuity can explain. Isn't this itself a most powerful corroboration of Jim's evidence? Given essential facts which imperatively call for explanation, and which nobody can explain without the Negro's help, what follows? As sane people, we must accept the Negro to that extent. If we accept him as to those unexplained and otherwise unexplainable facts, we need not bother our heads about other details of his evidence. We have enough to understand the crime and to identify the criminal. And when you remember that one of these two men, Frank and Connolly, successfully withstood a cross-examination of 8 hours, while the other refused to be cross-examined at all, your mind gravitates to the story of the man who was vainly assailed by the prolonged cross-examination. No suspicious tactics had to be used in behalf of Jim Connolly. No cook swore against him in the presence of her attorney and then took it back. No prostitute had to be spirited away from Atlanta on his account. No poor old preacher was paid $200, narrator's note, about $20,000 today, to make a false affidavit for him, and nobody acting in his behalf endeavored to bribe and to intimidate the state's witnesses. During the entire 2 years that have passed since Connolly confessed, narrator's note, that is, confessed to having been forced to become an accessory, and his boss ordered him to help with the body. So that's all he confessed to. Not a single bit of evidence has been discovered against him, other than that which he voluntarily gave against himself. And during that whole period, the hirelings of big money have never been able to unearth a scintilla of testimony in favor of Leo Frank. Narrator's note, the next sentence is quite important. It's a formal legal sentence, but it's an important one to please pay attention to. Circumstantial evidence, and what that means is, in this narrator's note, as opposed to eyewitness. You can convict somebody of a crime because a witness can say, I saw him do it. Or you can have the circumstances, such as somebody saw him go into the room, and then later on there was a scream and there was a pool of blood. And then they saw the open window and they heard the sound of somebody running. So that's all circumstantial evidence. Circumstantial evidence can be very important. Even if you don't see the crime being committed, you can still convict somebody and send them to the gallows or the electric chair. Okay, so going back, circumstantial evidence is sufficient to convict when a crime is proved and all other possible persons are excluded, save the prisoner at the bar. In other words, if you know a crime happened and every other person is eliminated as the possible murderer, except the one on trial, then it's that person. In this case, the guilt of Frank can be shown on two lines, independent of each other. The Negro's corroboration testimony does it, and the circumstantial evidence without the Negro does it. Narrator's note, here Watson is again emphasizing, because the northern Jews papers and some of the Atlanta Jews papers were all saying, oh, this poor white man is being sent to the gallows in the testimony of a drunken brute of a Negro. Over and over, and Leo Frank's going to hang because of some Negro. Over and over and over again, Jim Conley's a no-good Negro. And they trotted out all their prejudice and all their anti-black feeling, and they lied and said the only reason Leo Frank was sentenced to death is because of the word of a no-good Negro. This fine, upstanding white businessman. Well, Watson takes great pains to emphasize that yes, Jim Connolly does prove Leo Frank's guilt, but all the circumstantial evidence also shows his guilt. The 23 grand jurors thought so, and never changed their opinion. The 12 trial jurors thought so, and never changed their opinion. Judge Roan at least thought the jury was justified in its opinion, for he refused to disturb the verdict, and he never told anybody or wrote anything to the contrary. Narrator's note, what Watson is saying here is that after Judge Roan had died of cancer, a letter was quoted in the newspapers where supposedly Judge Roan had some doubts about the guilt of Leo Frank. And the firm assertion of Thomas Edward Watson is that this was a forged letter. Of course, how convenient, Judge Roan was already dead, and suddenly this letter pops up, at a time when Judge Roan cannot denounce it as a forgery. So it's an interesting way to get away with forgery is wait for somebody to die and then produce a letter and say he wrote it, and the person being dead can't deny it or make any comment on it. Back to the text. And the Supreme Court thought the same way, for it sustained both the judge and the jury. Next subheading, how came other states to interfere? Never before did we have outside influences brought to bear upon us in our enforcement of law. Narrator's note, what Watson is saying is, in the history of the trials in the courts of the state of Georgia, never has some other state or outside newspapers gotten involved with criticizing the trial or the verdict or criticizing a witness. The newspapers of Tennessee and New York and Montana and Oregon and California, they never got involved with a murder case, and this is a case of one little girl murdered by one man in a pencil factory. Normally there's not a lot of interference by other states and other newspapers in a local matter, and that's the point Watson's making. So, to repeat the sentence, never before did we have outside influences brought to bear upon us in our enforcement of law. We have tried Jews and Gentiles, rich men and poor men, white men and Negroes, and we have put many a man to death after precisely the same sort of procedure that was had in Frank's case. Why was Frank made an exception? Why was he singled out for a national crusade against the state of Georgia? Why did New York preachers and laymen get excited in behalf of this particular convict? Why did Chicago people turn their backs upon all the condemned murderers of the West and come Pullman carring down to Atlanta for Leo Frank?
Pullman car, narrator's note, is like a sleeper car in a train where you can, go to bed at night, and there's restaurants, and it's a very nice institution of railroad cars in the old days, the Pullman car. Back to the story. When before did governors and legislatures of other states assume that they knew more about our business than we ourselves knew? When before did the Jew papers, the L&N Railroad papers, and the Hearst papers arrogate to themselves the right to treat a carefully adjudicated case as if it had never been legally decided? The Louisville and Nashville Railroad belongs to the Rothschilds, of whom the New York Jew August Belmont is the American agent. It was the baleful influence of this L&N system that debauched Kentucky and Tennessee politics, caused the assassination of Goebel and Carmack, and is now the power behind the throne in Georgia. Narrator's note, what all this refers to is things which were well known back in 1915, but of course are, news items that are over 100 years old in our time. William Goebel was a Democrat who ran for governor of Kentucky. There were vast accusations of vote fraud, and he was very much against the Jewish-owned Louisville and Nashville Railroad of the Rothschilds and of their agent, the Jew August Belmont. He was shot and took 4 days to die, and there was great belief that he had been assassinated on the orders of railroad owners. No one was ever convicted of the crime. Whoever it was got away. Carmack was someone who in 1908 was shot and killed, who had also, he had been a politician and a newspaper publisher, been with the Nashville, Tennessee, and he was also against the tremendous power of the Jew-owned Louisville and Nashville Railroad. Returning to the article, what is to become of law and order in any state when outsiders claim the right to dictate to it? After this case had gone the way of all others, the rich Jews formed a finance committee, headed by Haas of Atlanta. Contributions were poured into its treasury, and even the Jewish clerks were assessed on their wages. Narrator's note, in other words, Jewish employees of various Jewish companies, they were expected to donate also. This was like the common cause of all of American Jewry. All Jews had to stick together, were expected to put some bucks in the kitty to get Leo Frank off. This became a Jewish crusade. Back to the story. The Burns Detective Agency spent money like water. Its own money, of course. In other words, they were submitting a bill. And in every direction, lawyers, politicians, and hack writers were enlisted. Narrator's note. Next comes an important sentence which I highlighted in my introduction. For Frank belonged to the Jewish aristocracy, and it was determined by the rich Jews that no aristocrat of their race should die for the death of a working-class Gentile, quote, nothing but a factory girl, unquote. The most outrageous misrepresentations were published broadcast throughout the country, and as none of the Atlanta dailies would allow anybody to defend the state, the repeated and undenied accusations were believed by millions of people whose common sense should have suggested to them that no Southern jury has ever convicted a white man on the sole evidence of a Negro. Narrator's note. Once again, Watson's making an important point here. He's well aware as a Southerner that Northerners were aware that there was a big race problem down south, and actually there was starting to be a big race problem up north as Southern blacks moved to New York City and Chicago, and there were race riots, and there was Ku Klux Klan up north also. But, there was certainly that image that the South, Southern whites had a low opinion of Southern blacks. And so Watson is making the point that these Northern whites who were so gullible should have asked themselves, would an all-white Southern jury really send their fellow white man to the gallows on the advice of a black guy, and especially an uneducated black janitor who'd been in jail for fighting and drinking and stuff like that. No. I mean, no Southern white jury was going to send a white businessman, a factory manager, to the noose on the advice, just in the testimony of one Negro. No, there was a lot more evidence that convicted Leo Frank, such as, among other things, the 10 white girls who said they had been sexually harassed by Leo Frank. There was all kinds of other evidence, as Watson points out. Yes, Jim Conley gave evidence that pointed to the guilt, but there was lots of circumstantial evidence. There was the evidence of the incredible nervousness of Leo Frank. There was the evidence of what the black cook, Minola McKnight, said, and that her husband then repeated to his fellow employees at the hardware store. So there was lots of evidence spinning out in every direction against Leo Frank. Leo Frank was not convicted solely on the testimony of an uneducated Negro. No Southern white jury was going to send a white man to hang just on the word of a black guy. Certainly not then. Next subheading, they dared not publish the record. Narrator's note. What Watson means by this is the official court record, the transcript of the trial, of all the evidence and the arguments by the lawyers for the defendant and by the prosecution, and the words of the judge and his instructions to the jury. In other words, the court record. And, of course, a stenographer is there typing and recording everything, word by word, in the American system. Again, they dared not publish the record. The reason why sentiment in Georgia crystallized against Frank was that I laid before the people the plain facts as they are preserved in the official record. Narrator's note. It's really very important, the role of, indeed, Thomas Edward Watson in this. He had both his weekly newspaper, and he also had his monthly magazine, and he kept returning again and again in the year 1914, a year after the trial, when he was surprised to see that this case was still going on in the media, and he jumped in at that point and said, look, I mean, he was clearly proven to be guilty. Watson really stood up against all the lying newspapers in his own state and in other states, and Watson kept returning over and over again in excellent writing style, and based on his 25 years of experience as a trial lawyer, a man who knew the law and how to explain the law and how trials are to be correctly conducted. And he explained all this to the public. So Watson was standing there like the Rock of Gibraltar for the truth, no matter what all these various newspapers in the state and outside the state were saying. Now back to the article. And the reason why so many honest people in other states have misunderstood the case and misjudged our courts is that the partisan pamphlets were believed to contain the truth. And of course, Watson's point is there's no Watson's magazine in California or Texas or Montana or Oregon or Illinois. The only place where the truth is being said is here in our own state, because I'm writing it and because I have a newspaper and I have a magazine. If the record had agreed with the pamphlets, what was the need of so many pamphlets? If the record failed to disclose any convincing evidence of Frank's guilt, why was it never published? There is but one reply. The record does show the man's guilt, and hence they could not print it. You may be asked, why did not the state publish the brief of evidence? In the first place, the governor was a member of the law firm which is getting the biggest fee in its history for saving Frank's life. But in any event, it is not to be expected that a sovereign state will appear as defendant at the bar of public opinion when arraigned by a Haas finance committee, a rotten detective agency, a regiment of feed lawyers, and a pack of nondescript publicists. A sovereign state may well maintain a dignified silence, conscious of the rectitude of her judicial proceedings,
and trusting to the imperishable official record to vindicate her from unofficial and irresponsible assailants. Now, of course, narrator's note here, Watson is addressing the problem that the courts do not publish newspapers to defend their decisions. Basically, the majesty of the law and the prestige of a judge is he makes his ruling and he slams down his gavel and court is adjourned, and basically you expect the public to accept the verdict. Judges don't have newspapers, and they don't explain their decisions except in the court record. But the problem is the court record be 300 pages, 600 pages, 1,200 pages, 1,600 pages, and the average Joe is not going to buy the book. Besides, nobody publishes a book with a court record. It's just not available to the public. And who's going to read 1,600 pages? But what people will read is a short article in a newspaper, especially if written in a jazzy and interesting style. If it's owned by Jews, that newspaper, then they're going to write some screaming editorials and talk about it's the end of the world, and anti-Semitism is casting its shameful shadow over America. These are terrible times, and they make it very interesting. So people read a short article, but they never read the court record, the transcript, the hundreds of pages of testimony, and they never see photographs or drawings of the evidence or pictures of the bloody dress of Mary Fagan and these other things. The average guy is just not aware of any of the details of the evidence. He just reads short articles. Back to the story. From the Pittsburgh Leader, I extract the following as a fair sample of the editorials in behalf of Frank. Few individual cases have attracted the attention and drawn the sympathy of the country as that of Leo Frank, under sentence of death in Georgia. No case has become so celebrated for the same reason, that a man was convicted in advance of his trial, and that the trial itself was a travesty. The country has been convinced that Frank is a victim of extraordinary prejudice. It takes unusual prejudice to make a man's life the price of his payment. This is a point which has remained hidden in all the reviews of the case since his conviction. In all the proceedings that have been taken by Frank's attorneys, and in all the reviews of the case, the evidence upon which he has been sentenced to death has not once been touched. Technical points have been passed upon, but not once before any court was the question of evidence discussed. The various courts took up and passed upon every other point, but the one most vital to Frank, that the evidence to convict, was lacking. And Thomas Watson comments, if you have paid any attention to what I've already written, you know how shamefully false was the statement made in the Pittsburgh Leader. The editorial continues, except in one little spot in Georgia, Leo Frank is looked upon as a victim of prejudice, mob law, and perversion of the legal machinery. Governor Slayton has taken up the application for executive clemency and promises to virtually retry the case. He's become impressed by the nationwide human protest against Frank's martyrdom, no less than the seriousness of the charges against the name of his state. The governor is receiving an endless string of letters from men and women all over the country, asking him to either pardon or commute the sentence, so he may have a chance to establish his innocence later. The individual letters to Governor Slayton have been strengthened by chain letters, which are rolling across the country. Letter chains have been formed everywhere and are moving like an avalanche toward the governor's office in Georgia. No better cause than this, the life of a man condemned to die, branded as a criminal because a mob demanded his blood, ever enlisted the energies and sympathy of the American people. The only hope for Frank is that the public's attitude make enough impression upon Governor Slayton to convince him that the case should be retried or its victim set free. Governor Slayton is intensely interested from the first, and never defended, even by the Georgia mob, that there was no evidence to convict any man except one picked out for an application of legal lynch law. Let every humane man and woman in America write a letter to Governor Slayton, make up chain letters to convince him that the guilt of Leo Frank is accepted only by a handful of men in one town in Georgia who want his life in a spirit of blood-lust prejudice. Write today and tomorrow and every day until Frank is pardoned, his sentence commuted, or he goes to death lynched by a Georgia mob. Write today. In addition to these chain letters, men were hired to stand at car stations in Chicago and other cities to enroll the name of every passerby who would sign a petition. Similar petitions were carried from house to house, store to store, office to office, until even the school children of other states were writing and telling us how to manage our affairs. Next subheading, enter Hearst and his Shuren. Narrator's note, William Randolph Hearst had a whole empire of newspapers across the United States and was infamous for what is called yellow journalism. Very, very sensationalistic, sometimes making things up, always in favor of war. He was a big pusher behind the Spanish-American War when the United States basically started a war with Spain and then went on to conquer Cuba and Puerto Rico and the Philippine Islands. And the whole war was totally unnecessary and unfair. The Hearst newspapers were beating the war drum, hence the expression yellow journalism, a very cheap paper which turned yellow quickly. So he was a disreputable press baron. Again, the subheading is Enter Hearst and his Shuren, the name of a person. Perhaps the most astounding piece of impudence was that of William Randolph Hearst, partner of Frank's people in the moving picture business. What this refers to is there was an early movie company making movies called the Hearst Selig Company. Interesting connection there between the Selig family, in other words, the wife of Leo Frank, and this press baron, William Randolph Hearst, who was not a Jew, he was a Gentile, but certainly worked closely with Jews to make money. He sent to Georgia his personal attorney, Clarence Shuren, in parentheses, of Jerusalem. By that, Watson sarcastically means he was a Jew, who happens to be, by the grace of Hearst, a member of the Supreme Court of the state of New York. When William Randolph Hearst whistled for his little Supreme Court judge, Shuren should have begged permission to remind his master that although he had responded to his master's voice, it would not look well for one member of the Supreme Court of New York to invade a friendly state, review a decision of her Supreme Court, and overrule it without notice to that august tribunal and without allowing it to be heard in its own defense. However, this is what Shuren actually did, as related proudly by himself. Narrator's note, next comes the text of an actual letter. New York, June 10, 1915. Dear Mr. Hearst, I went to Atlanta, as requested by you, for the purpose of making a careful examination into the case of Leo Frank, from the impartial standpoint of a lawyer who previously knew nothing about the facts of the case. Supplementing my full oral report to you, I state herewith, for the purpose of future reference, the result of my investigation. In order to arrive at a conclusion based solely upon the evidence, and before discussing the case with any person, I read the printed record containing the evidence introduced upon Frank's trial, and the argument to the jury made by State Solicitor Dorsey. I also read the State's brief on appeal, so as to be fully apprised of everything that the State claimed to have established against Frank. My deliberate judgment, based solely upon the record, and formed as a judge would reach a conclusion in passing upon it on appeal, is that not only did the prosecution fail to prove Frank to be guilty beyond a reasonable doubt, but that outside of the incredible and interested testimony of the suspected Negro Conley, an admitted accomplice, there is no legal evidence whatever in the case upon which even a reasonable hypothesis of Frank's guilt may be based. The irresistible conclusion to be reached on the evidence in the record is not only that Frank is innocent, but that the Negro is guilty. After this examination of the record, I interviewed and cross-examined Frank in the penitentiary for an hour or more. I then visited the factory where the crime was committed and carefully examined all parts of the premises involved in the crime which were mentioned or referred to in the testimony. This resulted in confirming the conclusion that I had reached on reading the record. Yours sincerely, Clarence J. Shern. It is safe to say that no state in the Union and no independent kingdom in the world was ever before subjected to such an indignity. It is on a small scale, but it is a gross indignity nevertheless. Narrator's note. Next, Thomas Watson refers to, again, a news item of that day of 1915, and this was about the outbreak of World War I, which was a war then going on, and the assassination of the Austrian Archduke Ferdinand, and then the Austrians, after the arrest of the assassin, they didn't feel that a proper trial would be conducted, and they felt the man would be treated like a hero for murdering the hated Austrian aristocrat, and so they demanded the right to send her judges down there to try the arrested assassin, and that's what he's referring to. And many people feel that Austria exaggerated and caused the war to break out. So that's the background of the next paragraph by Watson. Austria demanded of Serbia the right to send her judges to try the Serbian assassin of the Archduke Ferdinand, and Serbia's refusal precipitated the European War. Arguing from example, Hearst and Shern believed that Serbia should have granted Austria's demand. Shern's opinion bears the same date as Hearst's private appeal to Governor Slayton, which appeal was not published in Georgia at all, and was not given out in the North and West until June 23rd, 3 days after the sentence was commuted. Narrator's note. The point Watson here is making is that basically a lot of big shots were leaning on Governor Slayton, such as one of the most powerful press barons in the United States, William Randolph Hearst, and this judge of the New York State Supreme Court. The people of Georgia were not told at the time that these letters from very powerful national figures were being received by Governor Slayton, nor were the people in the rest of the United States being told in the North and the West, as Watson says. We're not being told until 3 days after the commutation of the death sentence to life imprisonment that all these big shots were applying pressure on Governor Slayton. Back to the article. In that private appeal, Mr. Hearst says, Frank was convicted on the testimony of the Negro Connolly. There were only 2 men that could have committed the murder, both of these men being in the building at the time of her death. Either Frank must have committed the murder, or the Negro must have committed the murder, so that the testimony of the Negro, which inculpated Frank, exculpated himself. Ought any man to be sent to his death on the testimony of a criminal, an ex-convict, a confessed accomplice, a proven perjurer, and one who would himself necessarily be convicted as the murderer unless he could succeed in fastening the crime upon another? Now then, is there any other evidence in this case which would tend to convict Frank? Any sufficient evidence of any kind or character to corroborate the statements of this criminal, this proven perjurer, and this vitally interested Negro? I have made as careful a study of the case as I can as a layman, and I am absolutely convinced that there is no such evidence, but my opinion as a layman on this point may not be of any special value. However, I have at hand to sustain my opinion on this matter, the opinion of one of the ablest lawyers and jurists in the state of New York. Narrator's note. Now Watson begins speaking again in his own voice, and he makes this comment. This ablest, not only of lawyers, but of jurists, was the little man from Jerusalem, Clarence J. Shern. Narrator's note. I might add parenthetically that Clarence J. Shern also attended the same university as Leo Frank, namely Cornell University, creating perhaps just a little bit of a partiality towards Leo Frank. Okay, back to the story. Now, as I have already shown you, the state at the time of Conley's confession had no evidence on him, but it did seem to have some on Newt Lee, and if Conley had not given away the joint guilt of himself and the Jew, the busy persons who forged the time-slip and bloodied the old shirt would have manufactured additional evidence against a perfectly innocent man. The overshadowing fact in the case is coldly ignored by Shern and Hearst, to wit, the fact that if one of these 2 men, Frank and Conley, is guilty, the other is.
If Hearst and Slayton had not both believed Frank to be guilty, they would never have stultified themselves by coupling innocence with life imprisonment. Innocence deserves a pardon. Either this man committed a crime which forfeits his neck, or he's entitled to go unpunished. There is no middle ground. Mr. Hearst is many times a millionaire, and he publishes numerous papers and magazines. If the official record fails to demonstrate Frank's guilt, Mr. Hearst would have published that record. To have done so would have cost less money than to send Messrs. Brisbane and Shuren to Atlanta, and it would have looked better. Next subheading: what is the pardoning power? As every lawyer knows, our statutes, constitutional clauses, and rules of practice are built upon the broad foundation of the laws of England. Without a study of the jurisprudence of the mother country, we cannot understand the true origin, scope, and purpose of our own legal system. Let any member of the profession turn to his Blackstone, Book 4, Chapter 31, and refresh his memory as to the pardoning power. All crimes in England were supposed to be committed against the king, who was assumed to be present all the time in his courts. The crime having been committed against the king, it was his royal prerogative to forgive it. But the king never retried a case. Such a thing was preposterous. The king never set aside verdicts and overruled his judges. Such a thing was inconceivable. Blackstone expressly says that it would be against all correct principles to allow the power of judging and of pardoning to vest in the same person. Blackstone quotes the great legist Montesquieu, who lays down the profoundly wise proposition that if a magistrate exercised both the power to judge and to pardon, such a combination of separate powers, quote, would tend to confound all ideas of right among the mass of the people, as they would find it difficult to tell whether a prisoner was discharged by his innocence or obtained pardon through favor. Chancellor Kent, in his Commentaries, Volume 1, Part 2, Paragraph 283, says, quote, policy would sometimes require a remission of punishment for a crime certainly ascertained. The very notion of mercy implies the accuracy of the claims of justice. Narrator's note: Watson is saying here that the notion of pardon or of mercy means the person was guilty, and there's some reason to forgive them, but there's no quibbling or disputing they committed the crime. In none of the authorities can you find support for the idea that the executive has power to retry and to pardon, because on this retrial he reaches a different conclusion from that reached by the jury on the same evidence. For an executive to exercise the functions of trial judge and traverse jury is to confound all principles of separate powers and to bring administrative anarchy upon the state. Now, when the pardoning power was written into our Constitution, along with the explicit separation of the right to try, the judicial, and the right to extend mercy, the executive, such lawyers as Jenkins, Rees, Matthews, Pierce, and Toombs never dreamed that any sane man would contend that the pardoning power in Georgia took a new, radical, and chaotic departure from the laws of England. When the Georgia Constitution of 1877 gave the pardoning power to the governor, it also put him upon notice that he must not exercise the power without a reason, which he must communicate to the legislature. The two constitutional clauses must be construed together, and when so construed in the light of English law and practice, they mean that the governor's reasons for executive clemency must be such that the legislature will approve, and such as will show to the people that he did not act capriciously, did not arrogate to himself the right to set aside the verdict, and did not usurp the functions of a Supreme Court of review. The prohibition of judicial powers to the governor meant that the executive must act upon something which occurred after the courts got through with the case, or upon some mitigating circumstance which tempered justice and softened the punishment of the guilty. The Constitution never meant that a governor could say, "I have retried this case," and return a verdict of not guilty. Nor did the Constitution ever mean that the governor should say, "I have retried this case," and find a reasonable doubt. Now, the Supreme Court has often said that, but no governor ever said it until Rosser's partner got hold of one end of the Leo Frank case. Next subheading: How did Slayton act in other cases? Consider how differently Governor Slayton acted in the case of Nick Wilburn of Jones County last year. Nick Wilburn had grown up in the backwoods, was a mere common clodhopper, never went to Cornell University, and never had girls under him working for $5 a week. The devil in the shape of a woman tempted him to eat the forbidden fruit, and he did eat. His sin was a grievous one, and grievously he paid for it. Governor Slayton refused to commute Wilburn's sentence, that is, a death sentence, and in declining to do so said, 23 grand jurors, 12 petty jurors, a judge of the Superior Court, 6 judges of the Supreme Court, 3 prison commissioners, all under oath, have declared the guilt of Nick Wilburn, and that the extreme penalty of the law should be imposed. I am sworn to uphold the law and enforce it. I sympathize with the family and friends of the defendant. It is a great pity that punishment cannot be limited to the offender. But if I commuted the sentence in this case, it would be equivalent to repealing the section of the code which provides for capital punishment. It is not in my province to make laws, but to enforce them. The responsibility for the verdict is not upon me, but the responsibility would rest upon me if I interfered with the decrees of a judicial tribunal without good cause. So what caused the change to come over the spirit of Slayton's dream between June 1914, when poor Nick Wilburn swung, and June 1915, when Leo Frank was slipped away from Atlanta in a Pullman Palace car? Next subheading, Slayton hanged a Georgia boy and boasts of it. In the Chicago Daily Tribune, the fugitive ex-governor of Georgia said, on July 10, 1915, they said I am afraid to allow a man to hang. This is untrue. I allowed a boy of only 18 years to go to the gallows. The Georgia boy whose death on the scaffold is cited by Slayton as a proof of his courage had never been in the habit of debauching $5-a-week work girls, nor had he ever been seen to commit the crime of Sodom, nor did he rape and murder a little girl who ought to have been in school. Therefore, Mr. Hearst did not send Clarence Shern to Atlanta to reverse the Supreme Court of Georgia in that case. Dr. C.B. Wilmer and Jake White did not ascend the throne of grace in behalf of just a plain, common, unromantic Georgia lad. It required all the peculiar horror, loathsomeness, and atrocity of the Leo Frank case to arouse that morbid interest, that weird fascination exerted by the crimes and criminals that are abnormally hideous, to influence the sensational Hearst, to enthuse Mary Delaney Fisher, to capture the doctors of divinity, and to set idiots to signing petitions. In that case also, the older of the criminals, Jim Cantrell, had been hired by a wicked woman, and he fell into her toils. Bartow Cantrell was a 17-year-old boy. He was wholly under the influence of his elder brother, and he probably had always done as Jim bade him. At any rate, he took part in the murder, not on his own initiative, and not for his own purposes, but at the instigation of Jim Cantrell and Mrs. Hawkins, the woman in the case. The Cantrells were brought up in sordid surroundings and discreditable conditions. In the midst of civilization, they were left untouched by the ennobling influences of church and state. In the midst of Christianity, a Bible was never put into their hands until both the church and the state said to them, "Prepare to meet your God." Next subheading, the law in the Cantrell case. In refusing to commute in the Cantrell case, Slayton wrote, "Under my oath, I must uphold the law. It is not my province to make laws, but to execute them. If the people do not believe in capital punishment, it is the duty of their representatives to repeal the law which provides for it." The appeals that have been made for clemency by good men and women are the promptings of kind hearts and sympathetic natures. Oftentimes apparent severity, however, is really philanthropy, and the enforcement of the law in this case may be the protection of many an honest fireside in Georgia, and may afford security to many an honest husband. The majesty of the law must be vindicated, and those whose kindly impulses urge them now to request clemency will, in their more thoughtful moments, recognize the necessity for law enforcement as a protection
to the civilization of our state. For the reasons stated, I cannot interfere, unless at the same time I am willing to make the declaration that, while governor, the law of capital punishment shall be repealed. This I am forbidden to do by my oath of office. This July 30, 1914, John M. Slayton, Governor. Next subheading, Slayton and another case of circumstantial evidence. In September 1914, there was an effort to save the neck of an old Georgian made by some people who had little money and no organization and no subsidized daily papers, no doctors of divinity, and no Hearst, Ox, Pulitzer, Strauss-Combine, and no champions among the snobs who were Slayton's best people. The old man was named Humphrey, and he was nothing but a tenant farmer. He was convicted on purely circumstantial evidence of having killed his landlord. He was sentenced to death, and there were a few generous Georgians in and around Dalton who took pity on the old man, upon whom a motherless daughter of 13 years was dependent for support. But Slayton felt no pity. He devoted no anxious days and nights to the study of that case. He made no mysterious visits to New York while that case was pending, and he had nothing to say against circumstantial evidence then. His snobbish soul could see nothing to appeal to him in the case of a condemned man who would not look nicely in the parlor of a Peachtree Palace, or in the elegant quarters of an Atlanta locker club. In the Humphrey case, there were no unscrupulous lawyers so highly paid that they forged a letter of a dead judge to use it before a governor who must have known it was forged. Who cared for the old tenant? He had no money, he had few friends, and these few had no more money than himself. Hang him on circumstantial evidence, hang him, and leave his little girl to the cold mercies of the world, a world in which she can do what Mary Fagin did, work where Mary Fagin worked, and fall a victim to some rich employer's lusts, as Mary did. And they hanged him. 9 months before Slayton repealed the law of capital punishment, abolished our jury system, obliterated 2 Supreme Courts, and rode into fame on the pretended mistake of law and a forged letter of Judge Roan, when Slayton told the New Yorkers that he meant to retry Leo Frank, and when he kept his word to those millionaire New Yorkers by going through all the evidence, visiting the factory, experimenting with the elevator, and listening to the most elaborate arguments on the details of the record. He cut loose from the laws of England, cut loose from the established practice of centuries, cut loose from the Constitution he swore to support, cut loose from the anchorage of honor, and flung himself upon the shoreless sea of shame. The maddening thing to the people of Georgia is not that one man's life has been spared, but that Jew money has done for a foul, sodomite and murderer, a thing that shatters all precedents, nullifies the highest law, sinks juries and courts into contempt, brings upon us a sickening consciousness that our public men and our newspapers are for sale, weakens the defenses of every poor man's home, and adds to the perils that beset every poor man's child. Ah, it is a sad day for Georgia. At last we know that a poor man's home and a poor man's child counts for nothing when big money starts out to muzzle the papers, libel the state, invent a case which does not exist, hide the case that does exist, and defeat the law as laid down by the greatest tribunal in the world. Woe to the state in which the poor man has just cause to ask, where is my protection? Where is the strong arm that should be my sword and shield? Where can I put my child to work and feel that she is safe? What has become of my rights, my safeguards, my dependence upon justice? Woe to the state when the poor man has just cause to say, I am nothing. They only show me consideration when they want my vote and when they put a gun in my hand to fight out the rich man's quarrel. I am nothing. The laws they make are against me. The burden of life is all mine, and none of the ease and enjoyment. I am nothing. If my boy whom the state neglected, commits a crime, he swings for it.
But if some rich man's son lusts after my daughter, lays in wait for her, leads her into a trap, assaults her, and kills her, I am asked to respect the law, while the law is hiring automobiles and parlor cars to take her vile destroyer into a fake imprisonment.
Narrator's note: the preceding paragraphs, where you experience the anguish of a working-class person to see that he can't get a fair deal and he can't get justice from the courts, is referring to a very ominous worry that people had, which was the fear of communism. This article was written in 1915. Just 2 years later, the communists came to power in Russia, the largest country on earth, and began slaughtering people by the tens of millions. And they were appealing, oh, we'll help the working class, we'll help the proletariat, we'll help them get justice, and a fair shake, and a share of the economy. Well, that was their excuse. The real desire was to kill people by the millions. It was a murderous ideology. What Watson is saying here is, woe to the state where you destroy the hopes of the working class that they can get justice and get fairness, and that the government will care about a murdered working class girl. So he is referring to a great issue at that time, and in fact, just 2 years later, the communists came to power in Russia. So everybody was concerned, if we do not allow the working class to have good economic conditions and fairness before the courts, they could turn to communism. And in Russia, some of them did. And now comes the final subheading and the conclusion. Governor Slayton has a clandestine midnight conference with his partner Rosser. It was generally believed that the Frankites had won over 2 members of the prison commission. When it became known that R.E. Davison had disappointed them, and that Patterson alone had voted for commutation, the Frankites were uneasy. They had failed in every court, had failed before the commission, and were left with a governor who was known to be a most uncertain quantity. It became an urgent necessity for some strong Frankite to see Slayton at once and brace him up. Rosser to the rescue. The case was on its last legs, and between New York and Atlanta rich Jews wailed lamentably during the few hours before Rosser got hold of his tricky partner. These 2 noblemen loved the darkness at that time, for reasons that have always been considered sufficient. So the noble Rosser went up a back street in his automobile, late at night, stopped it a block or 2 away from the governor's, and footed it through the alley, like an impecunious person who desired to purloin the portable property of an unsuspecting fellow creature. Rosser went into the home of Slayton, and remained for hours, and until after midnight. What Rosser said to Slayton in this clandestine meeting will never be known, but it was noticed that next day the lamentations of the Jews were replaced by sly grins and offers to bet 10 to 1 that Slayton would commute. Read the following, not as evidence of Frank's guilt or as proof of Slayton's hypocrisy and perfidy, but as a sidelight on events in Atlanta. Atlanta, June 22. Mr. Tom Watson, what I tell you I know to be true as God is light, and it is this. The Jews all gathered at the home of the Seligs on Washington Street, where Frank's wife and father-in-law live, and from 8 till 12 o'clock they had a regular old-time Belshazzar feast. They drank wine, highballs, whiskey and beer, and smoked and sang and had music, and there was not less than 120 automobiles full of Jews that came there from the time, I say, to the late hour. And they all knew Slayton had commuted Frank and were celebrating it. And I know a policeman who was on the streets yesterday to make out like controlling the mob, and he told me he passed the jail every night at 12 o'clock for a year, and going on duty, and never saw a light in the office of the sheriff till Saturday night. And he was surprised to see the sheriff sitting there like he was waiting for somebody. And suddenly a Jew came running up and tapped on the window. The sheriff raised the window, and the Jew whispered to him, and the sheriff smiled, and then the Jew ran off, and the sheriff closed the window. Now that showed conspiracy, and that Slayton was working with the Jews all the time. In other words, the Jews knew, some on Friday and some on Saturday, that Slayton had commuted the sentence. Defending his action, Slayton published an article said to contain 15,000 words. nearly half of them devoted to an attack on Conley, and the other half to misrepresenting the official testimony of the white witnesses. He pretended not to have reached a decision in the case until 3 o'clock Sunday morning. It was said that he signed the commutation a minute after the midnight of Sunday. When it became known that the governor had actually retried the case on the same old evidence that had been so often and so thoroughly threshed out in the courts, the state seethed with indignation. It was felt that Slayton had usurped an authority not vested in him by the Constitution, and that he had established the principle of one law for the rich and another for the poor. In the Wilburn case, he laid down the law correctly. In the Cantrell case, while he was hard as adamant, he was right as to the rigorous letter of the law. In the Frank case, he reversed himself at the same time that he reversed all the courts. Why the difference? There is but one answer. In the cases of Wilburn, Cantrell, and Humphrey, he was not of counsel for the accused. And in the Frank case, he was. Leo Frank is now at the State Farm. Narrator's note, the Milledgeville State Prison, which is a farm prison where the prisoners would go out and work in the fields, and they weren't kept cooped up all day. So it was a relatively nice prison. And it was called the State Farm. It was a farm prison out in the countryside. Back to the story. Leo Frank is now at the State Farm, an honored guest of the managers, awaiting his triumphant release from even the politely formal letters of the law. His little victim, whose upraised hands, fixed by rigor mortis, proved that she had died fighting for her virtue, lies in Georgia's soil amid a grief-stricken and mortified people, a people bowed down by the unutterable humiliation of having been sold out to Jew money. On the heights from which the immortals look into the lives of human beings, how vast must seem the moral distance between the little girl who died rather than soil the purity that God gave her, and the governor who brought this eternal disgrace upon himself and our state. A child died a heroine's death, and sleeps in a heroine's grave. The man is pilloried in eternal infamy. We gave him a clean commission, and he returned it to us covered with filth. The Constitution which he swore to respect he trampled into the mud. The great seal of state went, like a thief in the night, to do for an unscrupulous law firm a deed of darkness which dared not face the sun. We have been betrayed. The breath of some leprous monster has passed over us, and we feel like crying out in horror and despair, "Unclean! Unclean!" When John M. Slayton tosses on a sleepless bed in the years to come, he will see a vivid picture of that little Georgia girl decoyed to the metal room by this satyr-faced Jew, and he will see her little hands put out to keep off the lustful beast. He will hear her cry of sudden terror. He will see her face purpling as the cruel cord chokes her to death, and John M. Slayton will walk the floor a wretched, conscience-smitten man, and he will sweat blood. Many, many years ago, there was a sermon preached at Thompson by a man whose life was as pure as crystal, and who, now and then, was lifted into a simple eloquence that moved all who listened. John M. White was his name. Peace to his soul, for he is dead, and I loved him well. He was speaking of duty, of the higher path, and the old landmarks, of the honor that a man should guard, as a woman guards her virtue. Narrator's note, the next paragraph by Watson, referring to a sermon by a preacher named John M. White, is referring to the ermine. The ermine is a kind of very beautiful, very cute little white, furry weasel. It's just pure white. And it's a weasel, but it lives up in the northern parts of the world. And it's striking for its absolutely snow white. Back to the story. He told of the little ermine of the far north, the tiny creature of the snows, the unsullied Diana of the silent woods, so true to its instinct for purity, so loyal to the white drapery that God had put upon it. And the hunters, seeking its life for its priceless fur, smeared filth around the burrow where the dainty thing lived, and how this little dumb brute shrinking from a vile contact which would soil its spotless covering, fell into the hands of its enemies, preferring death to contamination. Narrator's note, of course, he's making a comparison to Mary Fagan, who was pure. She could have lived and survived had she slept with Leo Frank, but she preferred to die than to succumb and to give up her virtue. Are the old lessons lifeless? Are the old glories gone? Are there no feet that tread the old paths? Once there were men in Georgia, men who were afraid of nothing, save to do wrong, men who sprang to arms and went to death on a bare question of principle, men who would no more lie than they would steal, men who flamed into passionate indignation when the legislature was believed to have disgraced the state, men who caught the fire from the heavens to burn a law which outraged Georgia's sense of honor and justice. The sons of these men carried the gray lines and the tattered stars and bars farthest up the heights of Gettysburg, met the first shock of battle at Manassas, led the last charge at Appomattox. And the songs of these Georgians are today bowed down with unspeakable grief, for they feel that our grand old empire state has been raped. Like the Roman wife of old, we feel that something foul, something unutterably loathsome, has crept to bed with us and polluted us during the night, and that while the morning has come, it can never restore our self-respect. We have been violated, and we are ashamed. Narrator's note, that is the end of the main article, but Thomas Edward Watson chose to add some final refutation of some false breaking news, some last-minute things. He was clearly hoping that the people of Georgia would take action, and so he responded to some false rumors and false statements by William J. Burns at the very end of this decisive article which changed Georgia history. And this is what Watson added at the very end of his article in italics. Note, William J. Burns has stated that he was employed by the state of Georgia, worked on the case a week, and reported that there was no evidence against Leo Frank. Burns was never connected with the case at all until after our Supreme Court had carefully reviewed the evidence against Frank and declared it amply sufficient to show his guilt. Burns was never employed in any capacity by the state of Georgia. Second, Governor Slayton has told it all over the North and West that Judge Roan requested a commutation of Frank's sentence. This statement is false. Judge Roan continued to say, notably to his pastor and his daughter, that the evidence unquestionably demonstrated Frank's guilt, and not until Judge Roan had been dead more than 2 months was a forged letter presented, which stultified Judge Roan's record and contradicted his judicial declarations of record in this case. The end. Narrator's final note. 2 weeks later, on August 17, 1915, inspired by this article which you have just heard, the finest men of Georgia, the most heroic men of that state, went out and they hanged Leo Frank by the neck until he was dead.
You remember me when the west wind moves among the fields of barley. You can tell the sun in his jealous sky when we walked in fields of gold. So So she took her love for to gaze a while among the fields of barley. In his arms she fell as her hair came down among the fields of gold. Will you stay with me? Will you be my love among the fields of barley? And you can tell the sun in his jealous sky when we walked in fields of gold. I never made promises lightly, and there have been some that I've broken, but I swear in the days still left we'll walk in fields of gold. We'll walk in fields of gold. Some that I've broken, but I swear in the days still left we'll walk in fields of gold. We'll walk in fields of gold. Ooh. Since those summer days among the fields of barley, see the children run as the sun goes down, as you lie in fields of gold. You remember me when the west wind moves among the fields of barley. You can tell the sun in his jealous sky when we walked in fields of gold. When we walked in fields of gold. When we walked in fields of gold.